Good morning, Madam Court Reporter.
Good morning, Judge Sabree. How are you today?
Doing well.
Great.
Are we gonna can we get some people checked in? And
Sure.
Attorney Melbourne, I'll try to get your case. Ms. Jackson, we'll try to get your case called, checked in.
Good morning. The young lady signed in under Gloria. Unmute your device. What's your name for court? Gloria.
Gloria Dyer.
And what time was your matter today?
8:30 a.m.
Dyer. Okay, give me a second.
Okay.
Yes, you are in the right courtroom. You can place your device on mute. The court will be with you shortly.
Thank you.
Okay. You're welcome. Let me rename you. Marcelina. Unmute your device.
Yes, I'm here.
Good morning.
Good morning.
What's your name for court?
Marcelina Weathersby?
Your matter is at 8:30?
Yes.
Okay, give me a second. And you said Weathersby?
Yes.
What's the last three digits of your case number for 8:30?
It's gonna be 998. I believe. Oh no, sorry. Look like the case number is 233472. Is it the one with the LT at the end?
Yes.
Okay, so the last is 3LT.
No, the last three digits. What's the last three digits?
203.
I don't see you on the docket for 8:30 this morning. Can you give your number one more time, the whole number?
The full case number is going to be 233-472-03, and then the letters L and T.
And what judge does it say on your paperwork?
It says Judge Jack.
Okay, yep, you're in the wrong courtroom. I'm gonna give you another number to dial into.
Okay.
You ready?
1 segundo, please.
Sure.
Okay, let me just get a pen really quickly. Oh, here goes one. Okay, I'm ready.
360
360
538,
538
and then it's 4 zeros.
0000. Thank you.
You're welcome. Have a good day.
You.
Thanks. There's a person signed in under iPhone. Unmute your device. The young
Yes,
lady with the red and black on.
Sherry Boyles.
I'm not yet, Miss Boyles. Give me a second.
Okay.
There should be a microphone at the bottom of your device.
Is it me still?
No, you checked in already. The person with the iPhone.
Good morning.
Good morning. I'm sorry.
Okay, no
It's
problem.
Trisha King.
Good. What's your name? Trisha King?
Trisha King, yes, ma'am.
Okay, give me 1 second. Yep, you're in the right courtroom. You can place your device on mute. The court will be with you shortly.
Okay,
We
thank
rename
you.
you.
Yes, good morning.
Give me a second, please.
No problem.
The person signed in under iPhone. What's your name for court?
Eileen Hernandez.
Okay, give me a second. Miss Hernandez.
It's
Okay,
for
you are,
8.
yep, 8:30. Let me rename you. You can place your device on mute. The court will be with you shortly.
No problem. Thank you so much.
You're welcome. Mandy. There's a person on Zoom, Mandy, by the name of Mandy. Unmute your device, Miss Mandy.
Yes, ma'am.
Good morning. What's your name for court and what time is your matter this morning with Judge Sabree?
8:30, and I'm standing in for Dejan Clark.
Dejan Clark. And Dejan Clark, is that an attorney? You standing
No,
in for?
he's an occupant for.
Oh, okay. Okay, yep, I see you on here. Let me, Mandy. You for Dejan Clark? Okay.
Yes, ma'am.
What's your last name, Mandy?
Wilson.
Okay, give me a second. Let me read. Okay, you can place your device on mute. The court will be with you shortly.
Lay down. You gotta be quiet. He's peeing. You
Ms.
just.
Boyles. Let me see, share Boyles.
Hello.
Oh, okay.
Mr. Owens, the Juan Owens.
Yes, good morning.
Good morning. What time is your matter this morning?
8:30.
What's the last 3 digits of your case number?
247.
And do you have your paperwork? What's the judge's name on your paperwork?
Jack.
Okay, you're in the wrong courtroom. I'm gonna give you a number to dial into
Okay.
for Zoom. It's 360-538-0000.
Thank you.
You're welcome. Kimberly Maryland.
Hello,
Good morning.
good morning.
What time is your matter this morning with Judge Sabree?
8:30.
What's the last 3 digits of your case number?
059.
059.
Do you have Miss Jensen on there as well?
Yep, yes, I do. You guys are in the right courtroom. You can place your device on mute. The court will be with you shortly.
Okay, thank you.
You're welcome. Angela, Miss Angela.
Hello, how are you?
Good morning, finding you.
Blessed, thank you.
What time is your matter this morning?
It's at 8:30.
And what's your last name or
As
first?
my first name is Angelo. It's Mag-Faulkner.
And what's the last 3 digits of your case number?
121.
Okay, you the plaintiff.
Yes.
Okay, give me a second. Jamelia. Jamelia. Okay, let me see. The person signed in on the phone ending in 7013. What's your name for court? Good morning. Press *6, 7013. Press *6 to unmute yourself.
Good morning,
Good morning. What's your name for court?
Dominique DeShazo.
What's the last 3 digits of your case number?
I believe it's 201,
And what time is your matter?
9 o'clock.
Okay, give me a second. Yep, you're in the right courtroom. You can place your device on mute by pressing *6. Once you hear your name called, press *6 again so the court can hear you.
Okay, thank you.
You're welcome. Okay, there's another person signed in with phone ending in 0413. Unmute your device, 0413. Press *6 to unmute if you're on the phone. Good morning.
Good morning,
What's your name for court?
Allison Stinson,
And what time is your matter?
8:30 a.m.
Okay, give me a second. Spencer. What's the last 3 digits of your case number?
The last 3 digits are 071.
And it's for 8:30, 071.
Yep.
I see a Sharnika Green. Oh, no, I see you, Allison. You're the plaintiff. Okay.
Yes, I am.
Okay, let me rename you. You can place your device on mute by pressing *6.
Okay.
I'm a wreck again. I hate this shit.
There's another person signed in with phone number ending in 3005. What's your name for court? Unmute your device, press *6.
Good morning.
Good morning. What's your name for court and what time is your matter this morning?
Jerisha Arnett, and it's 8:30 a.m.
Arnett. Yep, you're in the right courtroom. You can place your device on mute. The court will be with you shortly.
Thank you.
You're welcome. There's a person just signed in under iPhone. Unmute your device with the red shirt on. Good morning.
Good morning.
What's your name for court?
Laquita Thornton.
And what time is your matter this morning with Judge Sabree?
At 9 o'clock.
Okay, give me a second, Ms. Thornton.
Okay.
Yep, you're in the right courtroom. Let me rename you. You can place your device on mute. The court will be with you shortly.
Okay.
The person signed in on the phone ending in 4588. What's your name for court?
Last
4588.
name Miller.
Miller.
Hi, good morning. Last name Miller. First name is KHLYE.
Yep, you're in the right courtroom. I'll rename you. You can place your device on mute. The court will be with you soon. Okay, Judge, I think I have enough signed in for now.
Okay. Any attorneys have any dismissals or resolutions that we can call right now? Let's do those first. And if anyone wants to speak to legal aid, please put a hand up, raise your hand digitally. Okay. Our party's ready on RP Unlimited. Kizzy Jack.
Yes, Your Honor.
Yes, Your Honor.
All right. Calling case number 22395701. This is RP Unlimited LLC versus Kizzy Jacks. This is a recall from yesterday.
Good morning, Your Honor. Shakina Melbourne, P number 78958 on behalf of the plaintiff.
Good morning, Your Honor. Ted Phillips, P 35900 for the defendant, who is present. Ms. Jacks, can you just state your name, please? You're muted.
Kizzy Jax.
Your Honor, we're here this morning, I believe, on my motion to dismiss. And our request is going to be that the matter either be dismissed so the parties can file a quiet title in circuit court, or that the matter be removed to circuit court for determination of title. The facts briefly, as we understand them, are that Ms. Jax entered into an agreement with J. Royale, that is the name of the owner of RP Unlimited LLC, we believe, in June of 2019. This is a property that was purchased from the Wayne County Treasurer for $500. That deed is Exhibit 1 of my motion. Ms. Jax agreed to make repairs and maintain the property. She did work to walls, ceilings, major plumbing work, things that a landlord would have normally done, but the agreement was that she would be purchasing the property. There was admittedly never any written document indicating that. In May of 2022, there's a deed that was issued from J. Royale to Kizzy Jax. It's kind of unusual that J. Royale lists his address as the same as hers. He didn't live with her, but indeed he did issue a deed. Ms. Jax had received a number of communications from the Wayne County Treasurer's Office regarding tax foreclosure. She inquired in July, and 400 Monroe was directed to the Register of Deeds, where she discovered this deed and assumed the logical that after paying $25,000 in payments over the years for a $500 house, after doing the repairs and things that she had committed to do, that the house was now hers. What she did not know is that then in August, there was, in that deed is Exhibit 2. In August, there was another deed, however, entered without her knowledge, alleging that she quitclaimed the property to this corporation that J. Royale is the owner of. There's no consideration given in that. And then there's no logical reason why a person who had been paying since 2019 on SSI and had done all of this work would willingly deed the property back to someone, to a new corporation. So our position is, Your Honor, that this is a fraudulent deed, the second deed, and that Ms. Jax is a legitimate owner. Given that this property was in tax foreclosure and removed from tax foreclosure, I don't know what the plaintiff's position is as to why they would issue a deed and then later go through another process for another deed. But I will not assume they were trying to commit some sort of fraud on the Wayne County Treasurer, but I will assume that they instead intended to follow through with the deal that they intended to do, which was to sell the property. And that is our position, and we would ask that the court either dismiss so a quiet title can be filed to work out to resolve the multiple deeds, or simply remove the property to circuit court so that there may be the same result. Thank you.
All right, thank you, Mr. Attorney Phillips.
Well, Your Honor, as the court may well know, in last year, properties that were in foreclosure would be removed from tax foreclosure if the property was occupied, owner occupied. They would not be removed if they were investor. So I'm not saying that the investor here concocted this May deed for the sake of getting his property out of foreclosure, which did happen. But it seems like me there's only one or two choices. Either that happened, or this was a legitimate attempt to conclude the deal that had been agreed to years ago, and $25,000 had been paid on a house for $500. And I would acknowledge that the fact that it was a $500 house doesn't mean that the plaintiff couldn't charge $100,000. But I am pointing that out to say that this is more than a fair deal. When one thinks of buying a house for $25,000, they may say, well, nobody buys a house for that. Well, it does happen all the time. And it does happen all the time with houses that are purchased for $500 originally, with little investment being put into them. So again, I would just ask that the matter be removed or dismissed so it can be resolved.
All right, Attorney Melbourne.
Good morning, Your Honor. I can give you more background story than the brief background that opposing counsel offered. Jay Rowland purchased this property in October of 2017, and that property was purchased from the land bank. He spent over $25,000 himself to make the repairs on the home. Jay Rowland is also a friend, co-owner, or they're in business with RP Unlimited LLC. So it's more than one member to this transaction. Between 2017 and 2018, all the repairs were done, and Ms. Jacks was the first person to move into the property with a signed lease agreement in 2018. Ms. Jacks, because she has been on a fixed income for all of these years, what the parties did was work with her to help reduce her rent. What does that mean? Ms. Jacks was willing to assist with some of the repairs in the home, not paying any money, by the way, but actually working on some of the repairs in the home to help reduce her rental payments. There has never been any purchase agreement, and according to the statute of frauds, all real estate transactions must be done in writing. If there was a purchase of this property, Ms. Jacks has not yet proven or provided any paperwork stating or showing that she purchased the property for any dollar amount. Nor did she offer to the court or to opposing counsel any documentation about the taxes that she would have paid out of pocket, especially if she's on a fixed income. My clients have paid all taxes and all repairs on this property, and Ms. Jacks has knowledge that she has been renting this property the entire time. In fact, we even have text message from Ms. Jacks where she's alleging these things and knows that she has never purchased this property. The reason this case was filed is because, as opposing counsel stated, by the time we get into COVID and the pandemic, there was issues with the property taxes on this home because, again, there's no payments of rent. There was a situation where you had to, only the primary resident could pay the property taxes to bring the account current. And despite the client going up there multiple times, Wayne County refused to allow him to make any payments on the property and specifically state.
Can I stop you?
Yeah.
Are you saying that no one else could have made a tax payment on this property?
That is correct, Your Honor. We even have a realtor that we can have come and testify to that fact.
Was that a redemption policy? Because I could pay your taxes right now. I could pay anybody's taxes right now. So
because
was it already foreclosed and it had to be redeemed by the owner occupant?
It wasn't foreclosed yet, Your Honor. It was in the process of being foreclosed. And the county would not let anyone make any payments on it. They actually closed out the account online. He could not make the payments online or anything of that sort.
Was that beyond mandatory February 28th date?
I'm sorry, Your Honor?
Was it beyond the date of February 28th on that calendar year?
Correct.
Okay, so it was foreclosed, just it had to be redeemed. Statutorily, it was foreclosed. Okay, all right. Continue on. I just wanted to make sure. Make that point.
So the client and the realtor who both drafted. I'm sorry?
Sorry, someone was knocking my, apologize.
Oh, okay. The realtor who drafted the August deed that's attached to the motion to dismiss, as well as the May deed, is the same person that went with the client to Wayne County with the cash money to make the payments on the property taxes, which took place. Ms. Jacks is not a stranger to the plaintiffs. In fact, the parties had even previous relationships where she was watching his kids for a period of time to help with the reduction of her rent. If this was somebody that he did not trust, why would he have his minor children or minor child at the house being taken care of? Needless to say, because Ms. Jacks is in a fixed income and during the pandemic, her fixed income reduced or whatever took place on her financial side, she was well aware that this was a situation for rental assistance. When we filed this case, the reason why we're even here 5 months later isn't because the court statutory or requirements by the Michigan Supreme Court to get adjournments. We're here because we were all in agreement to adjourn these hearings for her Sarah application. Why would she file a Sarah application for rental assistance if she thought she owned the property? Not only did she apply, Sarah said, well, it was denied because there was a deed at some point. We had to offer and provide the August of 2020 deed to Sarah. By the time we do all of this, though, the Sarah funding ended. Ms. Jacks then went on to get to another agency to request rental assistance, to which she was approved. However, now when we're in the preparation in our thought process, we're preparing for conditional dismissal. Instead, there's a motion to dismiss file where she's claiming full ownership of the property and that she should get it even if she has to negotiate in any way, shape, or form a purchase price. Ms. Jacks has no receipts of anything that she's paid for, whether that's repairs, whether that's the property taxes, even if when it was in statutory foreclosure and getting out, she never paid for that either. I'm not really sure why we should move this on a quiet title action or where this fraudulent deed showed up, but we are willing to either stay this case and move it to circuit court, stay this case, and then file a quiet title action in circuit court, explaining that with statutory or frauds, Ms. Jacks doesn't even have an ability to claim ownership to a property where she has no paperwork showing any title or purchase agreement regarding that. I think personally that this case should not be dismissed and that Ms. Jacks should be looking for a move out date because she's a renter, has been renting, failed to pay the rent, resulting in us being here, even as today. Ms. Jackson has not paid $1, whether that is before May of 2022 with the deed or after August, after the second deed. She's made no payments in 2022 at all. And now we're over a year and now she's claiming ownership interest to a property that she's making no payments on, no documents. And at this point, we're not even asking for money. We're simply requesting the recovery of possession of the property.
Brief response, Your Honor. I think counsel said she would be agreeable to a removal of the case. So if that's the case, I don't know that I need to respond much, but if that's not the case, I would just point out that she indicated at one point that the plaintiff had paid all the taxes. That is not so. And a check of the taxes that I made, that there's only been $90 paid since the property was purchased from the Wayne County Treasurer, not the land bank, but the Wayne County Treasurer in 2016. There are currently $6,521.80 as of yesterday owing on the property. And the only reason I assume it was not foreclosed in 2022 was because of the owner occupancy issue. As to the Sarah, we are one of the 2 Sarah sites in the city of Detroit, and I had my staff check and there was no Sarah application they could find. It is possible that we were not able to find something that was in Wayne Metro's records, but that's unusual. Generally, we can each check each other's to find out. We do know that there was an SER application, according to the defendant, for utility assistance. You could be a homeowner, you could be a renter, either way, and get utility assistance through SER. So again, Your Honor, I would say there is clearly 2 deeds. There is clearly a statement by a position taken by the defendant that she did not sign the second deed. And I would ask, based upon the conflicting deeds, that there be this case be removed to circuit or dismissed so that a case can be filed in circuit. Or if the court prefers to stay this matter, although circuit court matter is going to take some time, so I don't know that the court would normally stay a case in district court for as many months as that may take.
All right. Is Ms. Jacks here?
Ms. Jacks is here.
Yes, I'm here, sorry.
Swear to tell the truth and nothing but the truth.
Yes, sir.
Can you state your name again for the record?
Kizzy Irene Jacks.
Thank you. And did you ever receive a deed, a quitclaim deed for the property located at 15715 Madeline?
From the Register of Deeds.
I mean, did you receive a deed from anyone?
No, I received it from the Register of Deeds.
Okay. Were you aware that the property was deeded in your name?
No, I wasn't.
And what, did you ever deed the property over? Did you ever deed the property to RP Unlimited LLC?
No, sir.
Okay. So
I was unaware that he could put me out when I noticed the deed was in my name.
all right, I
I
may have
didn't
another.
put that deed in my name.
All right. Okay, thank you.
I was unaware that the deed was even in my name.
Okay, thank you, Ms. Jackson. Attorney Melbourne,
Yes,
Oh.
Your Honor, I'm here.
is your client here?
No, Your Honor.
Okay, because I want to know what the purpose of the conveyance of the deed was to Kizzy Jacks.
It
But
was
are
for
you, I'm sorry,
the,
are you denying the existence, are you denying the validity of J. Royale's quitclaim deed to Kizzy Jacks?
am I denied? Say that again, I'm sorry, Your Honor.
Are you acknowledging that the property was deeded from J. Royale to Kizzy Jacks?
Yes, that May of 2022 deed, correct.
Okay. All right. And
Both deeds were done at the same place. Both deeds were, like I said, drafted by a realtor that worked on the deed. But she's also a notary public. If we have to have her come in and testify, whether that's in circuit court or district court, we have no problem doing that. Ms. Jackson, all of the parties went to a particular address. I believe it was one of the owners of RP Unlimited LLC's home, where both deeds were signed. There was an understanding. The documents were notarized. I'm not sure how we got here.
okay, I think I know. I'm not going to make a determination, and that's not my jurisdiction to make a determination on title. However, Ms. Jackson stated for the record, her sworn testimony is that she never knew this property was deeded in her name. This is at the same time when the property had to be redeemed based on your testimony from the Wayne County Treasurer's Office. The only redeemable person would be the person who is the owner occupant, and this time being Ms. Kizzy Jacks. She's the owner occupant, and then a deed was filed to transfer the property out of her name back, well, into an LLC that's acknowledged as a partner of Mr. J. Royale. Logically, this seems like it, and Ms. Jack states that she didn't transfer the deed to RP Unlimited LLC. Based on the testimony you all presented and the argument, that's what I'm weighing this decision on, is that Ms. Jacks didn't know she had a deed in her name and didn't know a deed was drafted out of her name. And her signature is on a deed. So I'm going to leave this up to circuit court. I'm going to dismiss this without prejudice. You may refile, but I have issues with title, and I do not want this case to continue until a quiet title resolution has been filed. Once parties can prove they have time, you can refile this matter. But for now, it's dismissed without prejudice for the reasons set forth on the record.
Thank you, Your Honor.
Thank
Ms.
you, Your
Jacks,
Honor.
I'll see you in a breakout room. Your Honor, can I get breakout privileges, please?
Yes. All right, Ms. Boyle. All right. Is Jerisha? Our party's ready on Jerisha Arnett. Well, we have 10 minutes until defaults are ready, so I'll make sure I check the breakout rooms and we'll call some cases.
Excuse me, Your Honor. Could Kenitha Pearson, from an MLS legal assistant, also co-hosting, please?
Can I get those also, Judge? Good morning.
Thank you, Your Honor.
Oh. You are welcome. Ms. Boyles.
Yes.
I see you had your hand up. Are you requesting legal counsel?
I was trying to speak to the plaintiff, that's over the case.
Okay, let's see. You are. What's your last? Okay, 125.
Yes.
125, Sherry Boyles, Attorney Cox. That's being covered by Attorney Horka. Good morning, is Attorney Horka here? Let's see. See if I can put you on that breakout. Room 7. That was Ms. Boyles. You see an invite? Mr. Ajami, good morning.
Good morning, Your Honor. How are you today?
Doing well.
Attorney Hill and I are both ready on our recall from yesterday's docket. We have a conditional dismissal we'd like to put on the record.
Is this Bobby Erickson?
Yes, sir.
Calling case number 2334-5231. This is Doyen Detroit LLC versus Bobby Erickson and all occupants.
Good morning, Your Honor. Attorney Ali Ajami appearing on behalf of plaintiff in this matter, P84476.
Good morning, Your Honor. Ryan Hill, P68445 on behalf of the defendant, Mr. Erickson.
Good morning, everybody.
Judge, I think my client's on. Bobby, if you're on, can you take yourself off mute, state your name, please?
Yes, Robert Erickson O'Rourke.
Right.
Judge, sorry, Judge, that's correct. We've agreed to sign a CD, 45 days to vacate, and the parties reserve their rights in any subsequent action to sue for arrears and or violation of quiet enjoyment.
Okay, and those 45 days, where would that put us? May 11th.
45 days from the 11th. I can do that really quick.
Looks like Saturday, June 24th. So it'll be June 26th.
If we can just keep it a strict move out date, that'd be ideal. I have 45 days from today's date. I'm showing is Sunday, June 25th.
All right, so.
The Monday, then.
June 26th. Right.
Yes.
And then 4B will be checked off, Your Honor.
Yes.
Right. Okay. And do you need consent to sign for for your client, Mr. Hill?
Yes, Your Honor.
All right, Mr. Erickson,
Yes, Your Honor.
you give Mr. Hill permission to sign your name on the conditional dismissal agreement.
I do.
All right, the court is satisfied. Thank you, parties, for getting this done, and have a great day.
Take care. Thanks, everyone.
Thank you. Take care, everyone.
Thank
Your
you.
Honor, we will be submitting it. Should we fax it or email it? What's the court's preference?
You can fax this one.
Okay.
It's not too family, so fax it, we'll sign it and I'll get it back to you.
Thank you, Your Honor.
These are the last days of the fax machine.
Take care.
You too.
Good morning. There's a person named Gregory's iPhone. Unmute your device, Mr. Gregory. Good morning, Mr. Gregory. Unmute your device. Is the microphone at the bottom of your device? Or mute button, unmute?
Hello,
Good morning, Mr. Gregory. What's your
it's the matter of the estate of Dolores Carter and all occupants.
there's a person signed in under the phone number ending in 2132. Unmute your device. What's your name for court? 2132. Good morning. What's your name for court?
April Zena Smith.
And what time is your matter this morning in front of Judge Adam Sabree?
10 o'clock.
Okay, yep. You're in the right courtroom. I'll rename you. You can place your device on mute. The court will be with you shortly.
Okay, thank you.
You're welcome.
Go. I want to go right now.
Good morning. What's your name again for court? Unmute your device.
Laquita Thornton, my phone got bumped off. I'm sorry.
Okay, no problem. If it get bumped off again, when you have to come back in, just rename yourself so the judge will know who you are. We don't know who you are under iPhone. So what was
Okay.
your name again? I'll rename you again.
Laquita Thornton.
Thornton. Give me a second.
Good morning, Attorney Gann and Attorney Sartorio.
Good morning, Your Honor. Good morning, Your Honor.
Good morning. I'm gonna see if any default judgments exist, and then I'll call your case.
Thank you, Your Honor. Yeah, thank you.
Is Jerusha Arnett here? Jerusha
Yes.
Arnett. All right. Have you talked to the plaintiff's attorney? Are you represented by counsel?
We have
No,
not
I'm,
spoke, Judge.
Oh.
So you all haven't spoke?
No, Judge, I'd love to go into a breakout room with her if possible.
Okay. Let's see, are you named Miss Arnett? Can you say something?
Yes, I'm here.
I'll put you all in the breakout room.
Thanks, Judge.
Room 9. Mr. Marchese, good morning.
Oh, is that me, Judge? Hello.
Is Christopher Robinson here? Christopher Robinson. Does anyone live on First Street? calling case number 2-334-6087. This is Town Residents versus Christopher Robinson. All right, counsel.
Your Honor, I move for a default judgment for defendant's failure to appear, inclusive of court costs. The total amount owed is $3,248.94.
$3,248.94.
Yes, sir.
All right, and I think the Zoom missed your name and P number. Can you put that on the record for us?
Oh, I'm sorry. Dana Marquette, I thought I said that. P75872 for the plaintiff.
Okay, and this is a non-payment of rent case. Proof of service is in the file. Defendant failed to appear. Plaintiff requested a default judgment. The court's going to grant that. And defendant must pay $3,248.94 by, let's see, May 22nd.
May 27th. No problem, Judge. Thank you.
Yeah, May 2-2. May
2-2. Oh, okay. No problem.
All right.
All right, Judge. Have a good day. Thank you.
All right, you too.
Thank you.
Kimberly, Maryland here.
Yes. Speaking.
Okay.
How
All
you
right.
doing?
Doing well. Do you all have an attorney?
Yes, Brenda Richards.
Okay, is she here?
I don't know.
Okay, we have you checked in. We've had you checked in, but I'll see where Ms. Richards is, and then we'll call your case.
Okay, thank you.
You're welcome. Mr. Horka.
I have a few ready for you.
Okay.
First one ending in 125 at 8:30.
All right, calling case number 2-334-6125. This is Ligam LLC versus Sherry Boyles.
Yes,
Please state your name, Boyles.
Terry Boyles.
Thank you.
Good morning, Your Honor. Joe Horka, P75969, appearing for the plaintiff.
Good morning.
It's a subsequent hearing for a termination of tenancy. Ms. Boyles thinks she'll be out by the end of the month. And give her a couple extra days, make sure she is out and timely and comfortable. June 2nd is agreed upon consent judgment date. Again, just establishing possession.
Okay, so termination of tenancy case, you agreed to vacate by June, was it 2nd, you said?
Yes.
June
Yes.
2nd, that's a Friday, so they can't apply for a writ until that next Monday, which is June 5th. You are unrepresented, so Michigan Court Rule 4.201I applies, where if you think you made the wrong decision, you want to motion the court, you have 72 hours to file a motion to set aside this agreement. We aren't in person, Ms. Boyles, so Mr. Horka will likely be submitting this consent judgment. Instead of Mr. Horka, do you give him consent to sign your name on this agreement?
Yes, I do.
All right, there's not an amount to redeem. If you work something out with your landlord, get it in writing. But
Okay.
now the agreement is to vacate by June 2nd, 2023, and no writ will issue.
Okay.
All right, good luck, Ms. Boyles.
Thank you.
Welcome.
Thanks, Your Honor. Next one was 817 at 9 a.m.
817. Calling case number 2-334-5817, Logical PM versus Charlotte Williams.
Morning, Joe Horka, P75969, appearing for the plaintiff. Motioning this court dismiss this matter. We've been in contact with Attorney Rich. He has no objection.
All right, this matter is dismissed without prejudice.
You have 094, the Mark Landau case at 9 a.m.
Is it the Venetia Patterson?
Yes.
On case number 2334509 Emerald Springs Apartments versus Venetia Patterson and all occupants.
Good morning, Joe Horka, P75969, appearing for the plaintiff.
And Your Honor, Anthony Sartorio, P84851, standing in for the defendant on behalf of Benjamin Dietland.
All right, thank you, Mr. Sartorio.
Yeah, in our unfortunate situation here, it looks like Sarah was accidentally sent to a different incorrect landlord. The parties would like to adjourn this to see if we can address the issue. We're looking for about 3 or 4 weeks if you can accommodate.
Agreed, Your Honor.
All right, let's see. We won't be keep us. It's a good June day. June. June the 7th, Judge. June 7th is 1 in the afternoon. Yep. You want to come back in the afternoon?
That's fine with me, Your Honor.
That's fine, Your Honor.
Okay. June 7th at 1 o'clock.
Yeah, it was a folding bracket. It was Diane. Her name was Diane.
Okay.
Thank you, Your Honor. And I believe Ms. Patterson is present in the courtroom. So Ms. Patterson, your next hearing is June 7th at 1 p.m. and you're free to leave and you will hear from Mr. Dietland.
Thank you so much.
Of course.
You're welcome, Ms. Patterson. Have a great day.
You too. Bye-bye.
Keep marching along.
Good morning, Your Honor. This is Alan Dyer.
Mr. Dyer, Attorney Dyer, how can the court assist this morning?
Judge, I think we're ready to go on 058, and then I think I've got a handful of defaults from my 8:30 docket with you.
Okay, calling case number 2334605. This is Invest DTW Real Estate versus Jerisha Arnett.
Good morning, Your Honor. Alan Dyer appearing on behalf of the plaintiff P54857.
Thank you. Is Ms. Arnett here?
She was here. I know she was in a breakout room. I'm not sure if she was able to make it out.
Let's see if we can get her. She may have left completely. Ms. Arnett? Okay, yeah. Star 6, hit star 6 to unmute.
I'm here.
Okay.
Can you state your name for the record?
Jerisha Arnett.
Thank you, Ms. Arnett. All right, Mr. Dyer.
Judge, we did have the opportunity to speak in a breakout room. What we've agreed to do is enter a judgment via hearing against occupants only. We will dismiss Ms. Arnett from the case so that nothing is in her name. I'm giving her 30 days or until June 9th to vacate the property or to work out some other written agreement with my client that allows her to stay there. If she doesn't work something out with my client with a written lease or otherwise, then she needs to vacate by June 9th.
All right. Do you have any questions? Go ahead.
Yes. As far as with the 30 days, I mean, I've been here almost 8 years. It'll take me a very long time. And that's why I was not trying to move. I was trying to continue like a relationship with Mr. Neal. I followed through with the contractor and everything else. And I guess I'm waiting on a repairman that never showed or something.
Judge, I've got no authority to do anything other than proceed with the termination complaint. I did give her the maximum of my authority, which is 30 days. I did explain to her the statutory minimum is 10 days, but I am giving her 30 days. If she wants to try to work something out with my client, she can do so, but I've got no authorization to do anything other than to take a judgment today, and I'm giving her some additional time.
So what about the CR that's an escrow? He took the CR money.
The last payment, I understand, Judge, happened many, many months ago, and a 30-day notice to quit was sent on December 30th with a move-out date of January 31st. There's been no payments paid since that notice was sent.
Because they said that the escrow could not get released until he fixed on the house. He would get the remaining balance.
All right,
Again,
is the remaining balance in escrow going to exceed the amount that's currently been owed?
No, Judge. Ultimately, I believe she's talking about a prior case, a non-payment of rent case that maybe Sarah had some role with. However, this is a termination case. There's been no payments made on this account for many months, and my client is ultimately simply looking to get possession at this point, moving in a different direction.
Yeah, Ms. Arnett, when's the last time was a payment made on this property?
The CR was made this year for sure. A few months back. I can't exactly, because I did all the paperwork for that. The lady explained to me that he'll get X amount, which is like 10, 11,000 or something like that. And he'll get the remainder after he fixes something.
The remainder is 20%. And I'm trying to figure out when it was paid because this is a termination case. This is not a non-payment of rent case, it's a termination case. So they're not asking for the money. But in the event the 20% would have covered you through a couple months, that's really not relevant to this, but it's a consideration. But I don't know the last time you paid rent. You don't know the last time you paid rent. So why
now,
should
I only met him one time.
What'd you say, Ms. Arnett?
I've only met Justin Neal one time.
That doesn't change anything.
And he wouldn't even know if he liked me, if I'm a good tenant or anything.
Doesn't appear that he wants to maintain the landlord-tenant relationship with you, and he has every right through the termination of tenancy proceeding. So he's not asking for funding. The Sarah funding that's provided, I'm not sure if it will be credited or if there will be an excess in the event that the 20% that's escrow would credit, but this is a termination of tenancy case. So court's going to enter a judgment by hearing where all occupants must vacate by June 9th, 2023.
Thank you, Judge.
So Ms. Arnett, you really have until June 12th until a writ can be filed, but a writ can be filed against all occupants.
Okay, so I'm sitting and try to reach out to him.
Yeah, you can reach out to my client directly. You can call my office if you need contact information, ma'am.
I will.
Thank you.
All right. Good luck, Ms. Arnett.
Thank you.
Judge, it looks like I've got 59 through 63 with you. I think they're all defaults, but I'm not completely certain.
Kimberly Maryland is here. She said she had Attorney Richards representing her. I don't see Attorney Richards in here, but
I don't think that's my case, Judge. You said, what was the name on that again?
059. It's a Sheila Denson and Kimberly Maryland.
Okay, gotcha.
All right, is Taylor Todd here? On case number 233460660 LTD Property Management and versus Taylor Todd and all occupants.
Good morning, Your Honor. Alan Dyer appearing again on behalf of the plaintiff, P 54857. Judge, date and time set for a second hearing on our complaint for non-payment of rent. There's currently due and owing to plaintiff $3,075 in arrearage, $200.40 in cost, for a total of $3,275.40. Judge, we are asking for a default judgment.
27540. Defendant. Let's see. Defendant failed to appear. Let's see who Ali Dyer is representing. That doesn't look like the case. Default judgment is granted. Defendant must pay $3,275.40 by May 22nd, or writ may issue.
Thank you, Judge.
You are welcome. That's 060. On case number 233466062. This is Limited Property Management versus Georgia Hodges.
Good morning once again, Your Honor. Alan Dyer appearing again on behalf of the plaintiff, P 54857.
Thank you. And is Georgia Hodges here? Does anyone reside on West 7 Mile? On the 19,000 block of West 7 Mile? I don't see her in any breakout rooms. And no one by the name of Georgia Hodges has responded to the call of the court. So,
Judge, we are requesting entry of default judgment at this time. There's currently due and owing to plaintiff $12,825 in arrearage, $207.29 in costs, for a total of $13,032.29.
all right. Default judgment is granted. Defendant failed to appear. $13,032.29 must be paid May 22nd.
Thank you, Judge.
062. On case number 233466063, Limited Property Management and Development versus Georgia Hodges and Happiness Boarding Home.
Good morning once again, Your Honor. Alan Dyer appearing again on behalf of the plaintiff, P 54857. Judge, this is the date and time set for a second hearing on our complaint for non-payment of rent. There's currently due and owing to plaintiff $12,600 in arrearage, $206.81 in costs, for a total of $12,806.81. We are requesting entry of a default judgment at this time.
Default judgment is granted. Defendant failed to appear. However, it's very popular. And defendant must pay $12,802.81 by May 22nd, 2023, or writ may issue.
Thank you very much, Judge. Looks like all I have left with you is case ending in 059. I believe you said that Kimberly Maryland is here.
Speaking. I'm here.
And Ms. Maryland, do you have an attorney?
Ms. Brenda Richards.
Okay, Brenda Richards. Does anyone know, Brenda Richards is, she was Michigan Legal Services?
Yes, Lake Shore.
Lakeshore, she's with Lakeshore. Brenda Richards. All right. Have you talked to her, Ms. Marilyn?
Yes, we had an appointment on the 4th.
Yeah, did you talk to her today?
Haven't talked to her this morning. Tried to get her, and couldn't get through. What should I
Judge,
do?
I've not received an appearance on this file from Ms. Richards, so I'm not certain whether it's advice only or not.
Yeah, I'm not. Did they say that they were representing you and giving you advice only, or did they say they would take you on as a client?
They was representing us.
Okay, well, try to get in touch with your attorney, and the plaintiff's attorney is here. He would like to speak to you. There's some other legal representation in the courtroom today. You'd like to just speak to them and then speak to Mr. Dyer, but it's up to you.
Shit, if I get in touch with her today, what do I do after that?
Call the case.
I can call her now?
Absolutely. Today is the day and time for your case. So we'll get it done today, Ms. Marilyn.
Okay, so maybe I should speak to somebody in the break room.
Yeah, I'll invite you into a breakout room, and hopefully someone could talk to you, and then we'll call your case.
All right, thank you.
You're welcome.
If I can.
All right, attorney. Good morning. Is Gloria Dyer here? Gloria Dyer. Gloria Dyer. Calling case number 2334-6083. This is ID Capital LL. Gloria Dyer. Oh, Gloria Dyer is in room, counsel. She's in room 2. So I don't see her represented. I'm going to
She was speaking with one of our attorneys, Your Honor.
Okay. Do you know which one?
I believe she was speaking with Ms. Fisher.
Okay. Morning, Attorney Mexico.
Good morning, Your Honor.
All right, see if you can catch Ms. Fisher. And I'll recall your case. Looks like she's talking to someone in UCHC, but feel free to Attorney Adams, good morning.
Good morning, Judge. I believe I have a default.
Let's see. Does anyone live on Bramall at 15889 Bramall? Calling case number 2334-611. This is Daughters Land Company LLC versus all occupants at 15889 Bramall.
Attorney Allery Adams, P73324 on behalf of plaintiff. We're requesting an entry of default on our complaint to recover possession at 15889 Bramall, Detroit, Michigan.
Okay. 15889 Bramall. Does anybody reside? Does anyone have an interest in 15889 Bramall? Got 2 people in the waiting room. Let's see. Does anyone reside at 15889 Bramall? All right. Defendant has failed to appear. Default judgment is granted. This is a termination of the case. So defendants must vacate. All occupants must vacate by May 22nd, 2023, or writ may issue.
Thank you, Your Honor.
Cool. Have a great day.
Same to you.
Attorney Luan, good morning.
Good morning, Your Honor. We have a resolution with 6067.
On case number 233346067, this is Mathak Alarashi versus Eileen Hernandez.
And I don't see the other attorney. Oh, there she is.
On that one. Now Jack Francis on behalf of plaintiff's attorney of record.
And Suzanne Stepich, Lawan P 48702, Michigan Legal Services on behalf of the defendant Eileen Hernandez.
And counsel, I'm going to stop your video, Attorney Francis, because it was coming in, wasn't coming in clear. So can you put your appearance on the record one more time?
Now Jack Francis on behalf of plaintiff's attorney of record 272322.
Okay, that was a little better. All right.
And my client Eileen Hernandez is in the virtual courtroom with us. Ms. Hernandez, can you state your name, for the record, please.
Eileen Hernandez.
Thank you, Ms. Hernandez.
You're welcome.
All right. Were parties able to work out some type of resolution?
Yes, Your Honor, and with plaintiff's counsel's permission, since I'm having more stable internet surprisingly today, I will put the terms on the record. We have agreed to a conditional dismissal with a move-out date of June 15th. The tenant will allow reasonable access to inspectors and our contractors working toward a certificate of compliance on the property. And 4B is checked, but plaintiff will send defense counsel a courtesy email if a writ is applied for.
That's correct, Your Honor.
Okay. Hernandez, did we miss anything? Or any questions?
Hi, Your Honor.
All right, 4B is checked, which means if you follow through with this agreement, this case will get dismissed. If not, we don't have to go back to court, and a judgment plus a writ of eviction can be filed at the same time. All right, do you understand that, Ms. Hernandez?
Yes.
All right, well, good luck. We'll have a great day, and we'll enter this conditional dismissal. Oh, Ms. Hernandez, do you give Ms. LaFleur consent to sign your name?
Yes, I do.
All right. Anything else? Okay. You are welcome.
Your Honor.
Okay. Awesome. All right.
Ms. Hernandez, you can log off now.
Thank you.
All right, you're welcome, Ms. Hernandez.
Have a good day. Yeah.
You too. All right, Ms. Santiago.
Thanks, Judge. We are ready with Ms. Werner. It is case 23346-091.
On case number 23346-091, Argo Property Management versus Dejon Clark and all occupants.
Jessica Warner, P84628 with the plaintiff.
Good morning, Your Honor. Robert Santiago, Michigan Legal Services, P57157. On behalf of the tenant and occupant, Ms. Amanda Wilson. Mandy, would you please state your name for the record?
Amanda Wilson. I'm here on behalf of Dejon Clark.
Okay. Do you live in the property, Ms. Wilson? Do you live in 11620 Rossiter?
Yes, Your Honor.
Okay, all right. Good morning.
Good morning.
Judge,
All right.
we've agreed to a conditional dismissal under 4B with a pay or vacate date of June 11th, 2023. The current balance at this point is $4,864.04, which includes $161.50 for court costs.
You said 4,364?
No, $4,864.04.
Okay, 4,864, to be paid on or before, give me that date again.
Could be June 10th, actually.
2023.
You say, hold on. You say June 9th?
11th.
Sorry, Mr. Santiago, it would be June 10th, consider, because we're doing 30 days and this month it's 31 days.
Okay, June 10th, Judge.
Yeah, just.
June 10th puts us on a Saturday, so I'm gonna say June
Okay.
12th, because
That works.
that's a Monday, so
Yep.
June 12th. June 12th, 2023. So I don't believe that your name, Ms. Wilson, is on this judgment, but all occupants, including Dejon Clark, should have to either pay, if $4,864 is, this case is dismissed, or if parties vacate by June 12th, this case is dismissed. So, and in the event it's not paid or parties don't vacate, then the judgment and a writ of eviction can be applied for at the same time without going back to court. You understand that, Ms. Wilson?
Yes, Your Honor.
Okay, and do you give Mr. Santiago permission to sign your name on this consent judgment?
Yes, Your Honor.
Conditional dismissal, excuse me, it's a conditional dismissal. So.
Yes, Your Honor.
Okay. All right, I'm satisfied. Did I miss anything, counselors?
No, Your Honor.
I don't believe so, Judge. Thank you.
Thank you.
Right.
Thanks, Jessica. Good luck, Miss Wilson. I will
Thank
email you the document once I get it, okay?
All right, thank you.
You're welcome.
Welcome. Okay. Let's see. And I'll give you breakout privileges. All right, is Allison Stinson here? Allison Stinson?
Yes, I'm here.
Who is that? Who is, or?
This is Allison Stinson, the plaintiff.
Okay, and is Sharnika Green here?
Yes, I'm here.
Oh, did you all talk or come up with a resolution?
No, we haven't. I'm asking for her to vacate the premises by June 1st.
Are you in agreement with that, Ms. Green?
No, I need more time.
All right. Do you have an
She has
attorney?
been in the property.
Yeah,
She's been in the property.
Hold on, Ms.
Sorry.
Stinson. All right, Ms. Green, do you have an attorney?
No, I don't, Your Honor.
Are you requesting an attorney?
Yes.
I'm gonna invite you to the UCHC breakout room and then we'll call the case, once it's ready. How we call this case, Ms. Stinson? Well, I didn't actually call it. I just wanted to see what the status was. and I'll call it shortly.
Okay, thank
All right, let's see, let's get this 139. Attorney Sartorio and Attorney Yan.
Mr. Honor.
Good
morning, Your Honor.
Good morning. Okay, your file. Do you all have any matters in other courtrooms this morning?
I'm currently Zooming in Judge Sherman's courtroom.
I'm currently assigned to Brew, but I don't have any of my own cases currently up, Your Honor.
Okay, all right. And Mr. Gann, Attorney Gann, did you file anything in this matter other than the, let's see. Yeah, but did you file any responses? I want to make sure I didn't miss anything.
No, there's no responses. It'll be oral argument today, Your Honor. This was filed last Friday as kind of an emergency notification. And the only question is going to be whether or not the court will uphold the terms of the CD, because there's no dispute that she violated the CD.
All right, calling case number 2239-4139. This is the Peterborough Arms Limited. Lakita.
Hello, how you doing?
I didn't hear you.
Your Honor, there's a lot of static coming from a phone number ending in 1835 that's currently unmuted, it looks like.
Just gonna mute everyone. One way to do it. Okay, Ms. Thornton is here. Can you state your name for the record?
Hi, my name is Laquita Thornton.
Thank you.
You're welcome.
Good morning.
Good morning.
And Attorney Gann, Attorney Sartorio, to get your appearances.
Hey, please, Madam Court, Steve Gann, P78219, appear for the plaintiff.
And Your Honor, Anthony Sartorio, P84851 on behalf of the defendant.
All right. Parties are here because this is an oral argument scheduled. It's a hearing scheduled in response to an emergency motion to stay the writ, stay a writ of eviction. Emergency motion was filed last week. Parties were both in the courtroom, so we held an impromptu hearing, but the court stayed the motion pending a hearing. So today is the date scheduled for this hearing. So I'm going to hear both arguments on why this writ of eviction shouldn't be signed. And to back up, I believe a conditional dismissal was entered in this case where the defendant was to pay a certain amount, failed to pay that amount. The judgment, the affidavit judgment and writ of eviction was filed with the court. Then an emergency motion to stay the eviction was filed and granted, and now we're here. So I'll leave it to the attorneys.
Well, first, Your Honor, I would like to request, if possible, a 1-week adjournment. Ms. Thornton has spoken with Michelle Johnson at Legal Aid and Defender Association, and they're working on an application for financial assistance to pay the total amount that's owed. All of the funds to bring the tenant completely current. They just need a little bit of time to process and a couple of documents from Mr. Gann's client. So my first request would be that we adjourn the case 1 week so that could be processed and all the funds could be paid to Mr. Gann's client.
Okay. And what total amount is owed right now? The parties know?
Yeah, I can pull up a ledger in a second here. Looks like the balance currently owing is $4,310. And that's inclusive of the May rent, I do believe. Yes, it is.
An objection to a 1-week adjournment.
I do have an objection to 1 week adjournment, Your Honor. My client does not desire to continue with the tenancy. That this has been a very troubled payment history for this resident. They agreed to a conditional dismissal back in January, giving the resident a chance to make payments. Resident failed to make payments for basically 3 months in a row. They filed their objection. They filed the paperwork to reinstate, get a judgment written. It wasn't until after the paper was filed and served on them that she went and purchased the money orders. The money orders are attached to the defendant's objections. You can see by the dates were purchased after we filed our motion to reinstate. So basically the only reason why she even went to get money orders is because my client had to spend more attorney fees to get this case moving again. And my client really, it's a matter of, if the court is, we're going to ask the court to enforce the terms of conditional dismissal. And the courts as a whole have encouraged the use of conditional dismissals. Plaintiffs have gone along with it because it gives them some enforcement powers and a light at the end of the tunnel. If the courts won't follow through with enforcing them, the plaintiffs lose their incentive to keep working out resolutions with defendants. My client has spent an enormous amount of legal fees trying to chase down this money, and they're really at this point just wanting to move her out and get somebody who will actually pay in.
So, Your Honor, I would just like to state that this was initially filed as a non-payment case. So they were looking for payment of the rent in that case. Ms. Thornton's employment is seasonal in nature. Work had not yet picked up fully in March. On top of that, Ms. Thornton's mother passed away at the end of March after the conditional dismissal between the parties was entered, and Ms. Thornton struggled in contributing to the funeral costs and meeting her other obligations. But Ms. Thornton has been working really hard and has been able to save the funds required to pay herself current through May 2023 under the terms of the conditional dismissal agreement. And those funds are currently being held by United Community Housing Coalition. Per MCR 2.612 C1F, the grounds for relief from judgment on motion and just terms include that the court may relieve a party from final judgment for any other reason justifying relief from operation of the judgment. Ms. Thornton is the beneficiary of subsidized housing and just went through the passing of her mother. Should a judgment enter, Ms. Thornton could be evicted and potentially made homeless and lose her subsidy because of the difficult circumstances surrounding the death of a loved one. As Ms. Thornton has the ability to pay herself current on the conditional dismissal through May, there's little prejudice to the plaintiff in denying their request to set aside the dismissal, allowing Ms. Thornton to pay the delinquent balance and continue under the terms of the conditional dismissal going forward. Therefore, we would ask that the court deny the plaintiff's request.
If I may rebut that, Your Honor. One issue is, and first off, I feel sorry that she's lost her mother. That is a terrible thing, but she was behind in her payments prior to the loss of her mother. Defendant said that she had used the funds to help with funeral expenses, but she was already behind a month before her mother passed away. So it's hard to see how that comes into play here.
Well, my understanding, Your Honor, is that Ms. Thornton had made her payment for February and was unable to make her payment in March, and her mother passed in March.
All right, sorry for your loss, Ms. Thornton. We're not gonna make that the topic of contention here, but all right. So what were the terms of the original conditional dismissal?
The terms of the original conditional dismissal, Your Honor, pull that back up here, that she was to pay, make payments beginning February 15th for 5 months through June. and she was supposed to be told 25, 28 in past due under a payment plan that included a 6-month payment plan. So she should have made those payments beginning February, March, April, May, and June to get July to get this resolved. She missed the March, April, and May payments. Actually, March and April payments. May would have been included in the money orders that defense counsel attached to his objection. Well, those were already purchased. They were purchased after we had submitted our paperwork, after my client had spent more attorney fees to try to get the resident to pay.
All right, and all right, the major issue is that an agreement was made and an agreement was breached. If I had to base this not off of the conditional dismissal and what would, I mean, all right, this is the case. As counsel stated, if this conditional dismissal isn't enforced, I lose a lot of integrity with the conditional dismissals that were entered. So I'm going to enforce this conditional dismissal because defendant failed to make the payments timely. And that, as a result, as agreed upon by all parties, will result in a judgment, well, affidavit being filed, a judgment being filed, and a writ of eviction. I appreciate the efforts of you, counsel, and I am empathetic.
Your Honor, I would ask, if you're going to be entering the judgment in the writ, I would ask that the execution of the writ be held for a week or two to allow Ms. Thornton to either acquire the funds to pay the full amount or to move from the property.
All right, is there any objection for that?
Yeah, I believe I'm going to have to resubmit a new judgment and writ. So I don't want to put any delays on this because it's going to take a little time for it to get through the clerk's office to your courtroom. If she works something out with my client, we can always set that aside. But at this moment in time, I don't believe they're willing to work on anything as far as accepting of the funds. So I would like to be able to submit a new judgment and writ because I believe last Friday you set aside the judgment and writ. So I'll submit a new judgment and writ today. Because it's a writ, I'll send it via UPS because you'll want the full document signed and get copies to the court officer. So because of that, it's going to take a few days to get through the system anyways.
Okay, yeah,
I would still ask that the writ state that it's not to be executed for at least a week or two, Your Honor, if you're willing to do so, to allow Ms. Thornton the time to vacate or pay and stay.
I can say the writ. I'm gone the 18th and 19th. So if it gets to me, okay, I can stay the writ until May 22nd. Writ won't, I can guarantee the writ will be stayed until May 22nd.
Yeah, may I put on the terms, writ can be signed but not executed till after May 22nd. I'll put it on the terms of the writ itself. That way the court clerk's office will still file it and get it to your desk.
Yes, I'm okay with those terms.
Thank you, Your Honor.
And so to be clear, you didn't accept the money from Ms. Thornton.
That is correct, Your Honor. We have not accepted any funds since we filed the case, since we filed the motion to reinstate.
Okay, and if your landlord is willing to accept it, that's one thing. I can't guarantee it. That's up to parties. Thank you, Mr. Sartorio, and Ms. Thornton. Your attorney's work did lead to some type of relief. I believe a writ would have been executed by now, but for him filing this and getting in front of the judge. So, I mean, there's some silver lining. Did buy a little bit of time, and hopefully or maybe you can get some more, whatever the situation may be. But good luck, Ms. Thornton. I will sign this judgment and writ, but it won't be executed. It won't be executed until after May 22nd.
So the money, I had paid them March.
Ms. Thornton, we can speak in a breakout room.
Okay.
All right, good luck. Thank you, Mr. Sartorio.
Thank you, Your
Good
Honor.
luck.
Thank you, Mr. Gann.
Thank you.
Thank you, Mr. Gann.
Your Honor, if you might, if someone who has authority could put me into a breakout room with Ms. Thornton, I would really appreciate it.
Okay. Ms. Carey, you gonna take care of it?
Yes, Your Honor.
Thank you.
Thank you.
Judge, this is Alan Dyer. I think I have one final case with you ending in 059.
I think we do. And Ms. Marilyn, what's going on with your attorney situation? Let's see. Wow. I'm going to invite you in the room. Well, I'm going to invite Attorney Fisher and you into room 11. She's been in there with her for a while, seems like. Or maybe not, but let's see. Room 11, see if you have something.
Thanks, Judge.
Cool. All right, is Sharnika Green represented yet? No, she's still in the lobby. I don't think anyone's talked to her yet. Jasmine Jones. Jasmine Jones here. And Attorney LaJuan.
Yes, Your Honor. The parties are all here for 4390. We're here to provide you with research on the issue of eviction of the partner of a owner of the home. I don't know if you want to do that now or if you want to wait. You just let me know.
All right, I do see Mr. Aldridge. Good morning. Good morning, sir.
Good morning.
All right, we're gonna get to your case a little later in the docket. I'm gonna go through, I don't want to see if I can clear out some of this 8:30 and 9 o'clock docket, and then we'll call your case.
Thank you, Your Honor.
I'll put you back on mute, Mr. Aldridge, but keep an ear to what's going on, but I know you're here in any event. I know you're here, so you won't get too far. And thanks for that reminder. Counsel, Attorney Maximco.
Your Honor, I have this 8:30 case. I have no idea whether anyone is representing the defendant. I'm just hanging out here for one case.
Find out if you're represented. Find out counsel.
What case is that, Mr. Maximkoff?
Looks like Gloria Dyer's in room 2, so we'll see if she's represented.
Attorney Fisher spoke with her. I believe that she was looking for Mr. Maximkoff for a while this morning.
All right. And 1835. Attorney Maximco, the party's ready on.
So, Your Honor, I did have a chance to speak with the defendant. She stated that she was told that she is represented by Attorney Fisher. So I guess I couldn't speak with her.
Okay, she's in room 11 with Attorney Dyer. I'll see where they go or try to catch her after that. And then
thank you.
And Ms. Carey, Have anything else?
Yes, Your
No.
Honor. I just wanted to clarify for yourself in the court that Ms. Green from case 071, we are not able to represent her. She does not qualify for our services.
Okay. Ms.
So
Green,
if she
thank
wants
you.
to speak with the plaintiff, that, you know, that can happen.
Okay, thank you. Thank you, Ms. Green. And are you 1835? Ms. Green. Arnica Green. Allison Stinson,
Yes.
I'm gonna put you in the breakout room. All right, calling, is Sharnika Green in the lobby?
Right here, Your Honor.
Calling case number 2334607. It's Allison Stinson versus Sharnika Green and all occupants. And both parties, Ms. Stinson, can you state your name for the record?
Allison Stinson.
All right, and Ms. Green, can you state your name for the record?
Sharnika Green.
All right, thank you. Ms. Stinson, are you the owner of the property at 21488 Bennett Street?
Yes, I am.
You have proof of service. This is a summons and complaint to recover possession of property. Are you, Ms. Green, still, are you, not gonna say still, do you reside at 21488 Bennett Street?
Yes, I do.
Okay. And do you have plans to vacate that property?
Yes, but I need more time than June 1st.
All right, how much time are you requesting?
Like the end of June.
All right.
I would like to say, Miss Green, I got the property quit claimed to me in July. Miss Green was behind on her rent when the property was quit claimed to me for June. So I gave her a little while. I gave her until the middle of August, and I tried to call her. She didn't answer. I contacted her again at the end of August, and that's when we were able to make contact. And she told me that the hot water tank, something was wrong with the hot water tank. At this point, she was 2-3 months behind on rent. I told her that I would fix the hot water tank and I would need at least 2 months of rent, and she did not agree to it. And she hasn't tried to contact me. She told me in August that she was going to move out my property. She told me in September she was going to move out my property. This also is not the first filing that I've made for Miss Green for the property. I made a filing in October, and unfortunately I missed the court date, so I had to do the filing all the way over. So Miss Green has been well aware that she was going to have to move out of this property. So that's why I'm asking for June 1st.
Okay, Your Honor, I would like to say something also, because before she got the property, we already needed the hot water tank, the furnace is not working, and also the basement was backing up. I told her I will pay her when they fix those things. The original owner before her didn't fix that, so I didn't pay her either. And we were supposed to meet up, Allison and I. She missed the date that we were supposed to meet up. That was her fault.
I have text messages to show Miss Green.
And I also have text messages
telling you. Yeah, we both should.
She want to collect rent, but she does not want to fix up the house. As far as the hot water tank, I put the hot water tank. I put
Like
it
I
in.
just said, that I told you were 3 months behind on your rent, and I told you that I would fix
I
whatever
was
repairs
1
needed
month
to be done
behind
on
my
the house.
rent and I didn't
Once,
pay because the hot water tank in the basement was messed up.
okay, I'm asking for June 1st for her to be removed from the property. She's very hostile. I can't do it with Mr. Green. I'm sorry.
June 1st, Ms. Green. Right. Court's gonna enter a judgment by hearing. Defendants must vacate by June 15th, 2023, or a writ may issue. June 15th is between both of your requests. Good luck, Ms. Green. Good luck, Ms. Stinson. You can apply for a writ of eviction on 16th.
Thank you. Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome, Ms. Green. Attorney Phillips.
Ready with a 9 o'clock, Your Honor.
All right. What case is this?
201. I think there's only one on my list for 9.
Calling case number 23345-201. This is Helen O'Dean Butler Apartments versus Dominique DeShazo.
Morning, Your Honor. Ted Phillips, P 35900 for the defendant. And the defendant's present in the courtroom. Ms. Chazo, could you just state your name, please?
Dominique DeShazo.
Your Honor, this is a case with Attorney Brian Butchart on the other side, and Renia Haddad is covering today. She and I talked, and she's agreeable with a adjournment to May the 24th. There was a recertification issue for tax credit housing, and she did not have an answer back from her client as to what the status was. And we agreed that I would ask for an adjournment of the 24th or whatever date is convenient with the court.
Okay. I think we have a case on May 24th. Counsel, it's already.
I'm sure I have several, but that's fine.
Okay, so May 24th. Ms. Haddad, are you okay with May 24th? Is she here?
She's not present. She said she was okay with that date, though.
Okay, well, court find good cause to adjourn this matter to May 24th at 9:30 a.m. to resolve any pending issues that exist.
Your Honor, could the court hold this file aside for us to get a copy the next day or so?
Yes.
Thank you, Your Honor. Oh, is there a Earl Buffington in the courtroom? I'm trying to reach an unrepresented landlord to see if we could talk. And I don't see him.
Earl, was it Earl Buffington?
Earl Buffington, a 10 o'clock case.
Earl Buffington.
I'm speaking. I'm here. Earl Buffington.
310-713-1335 on the phone.
Yes.
His hand up.
1335. Okay, I will put it up, Mr. Buffington. I'm gonna put you in a breakout room.
Okay.
Mr. Dyer.
Hello.
Are you gonna get invited?
I'm here.
All right, I'm assuming that you've got a hold of defense counsel on 059.
We did, Judge. We spoke in a breakout room and I believe we've reached a resolution. I'm not sure if she's back from the breakout room or not.
Like she's in room 3. Someone on her team can put it on the record if that's possible. Is she? For Kimberly, yeah, both parts, all right. So, calling case number 2334-6059. This is LTD Property Management and Development versus Shalia Denson and Kimberly Maryland and all occupants.
Good morning once again, Your Honor. Alan Dyer appearing again on behalf of the plaintiff P 54857.
They're not coming out of the breakout room, so I'm going to recall it.
Okay, thanks.
All right. Is Jasmine Jones here? Jasmine Jones. Breakout rooms will exist for another 3 weeks. Ali Al-Sadoun. Ali Al-Sadoun. What's that yesterday? Yeah. Dwight McGee and Vivian Broaden.
I'm here, Your Honor.
Okay, I'll be checked in. Okay, I see Attorney Fisher. I'll call you. Recalling case number 2334-6059. This is limited property management and development versus Shalia Denson.
Good morning once again, Your Honor. Alan Dyer appearing again on behalf of the plaintiff P 54857.
Good morning, Your Honor. Janetta Fisher with Michigan Legal Services, P 72872, representing the tenant Sheila Denson. Sheila, please state your name for the record.
It's Shalia Denson.
Thank you, Ms. Denson. Good morning, Ms. Fisher.
Good morning.
Were parties able to work out a resolution?
We were, Judge. We spoke in the breakout room, and what we've agreed to do is enter into a conditional dismissal wherein we convert the case from non-payment of rent to termination with a move-out date of June 11th with box 4B checked.
That is correct, Your Honor.
All right. And Ms. Fisher, do you, Ms. Maryland, do you give Attorney Fisher permission to sign your name?
Yes.
Okay. And in the event parties vacate by June 11, 2023, this matter will be dismissed. And in the event parties don't vacate, a judgment and a writ of eviction can enter, which would prompt an eviction.
I agree with that.
Okay. All right. Good luck, Ms. Fish, Ms. Maryland, and court will enter this conditional dismissal. This is converted from a non-payment to a termination of tenancy where all occupants must vacate by June 11th.
Thank you.
Thanks, all. Have a great day.
Thank you, Your Honor.
Okay, you're welcome. You're welcome. Yeah. I'll get you out of here. All right, did you say Dwight McGee is here?
Yes, I am.
Did you talk to Ms. Broaden?
No, I haven't.
Or do you all want to have a conversation?
No, I don't.
All right, and Ms. Broaden, do you do you have an attorney?
No, I don't, sir. It's just me and God.
All right. Well, do you want an attorney?
You think I need one?
I'm staying out of this. I'm just They're here.
Me, I can speak on my behalf. I got a couple facts, you know, if that's okay, if I'm able to speak on my own behalf.
Okay. Let's see, I don't see any parties that are ready to see. Let's, Attorney Maxim Cobb, do you have a solution in your case?
Your Honor, the opposing counsel never contacted me. I can't contact her, so I'm just waiting.
Miss Attorney Fisher, I'm going to
Yes,
you in.
yes, thank you.
All right.
Thank you, Your Honor.
Room 15. Calling case number 2334-6096. This is Dwight McGee versus Vivian Broaden.
And all other occupants.
And all other occupants. May I have appearances, please? Can you state your name, Mr. McGee?
Dwight McGee.
Thank you. And is Vivian Broaden here?
Yes, she's here.
Okay. And is anyone else who lives in that property present?
Me, Denisha Broaden.
All right. Good morning, Ms. Broaden and Mr. McGee.
Good morning, Judge.
Is it safe to assume that parties haven't worked out a resolution in this matter?
It's safe to say that.
Yes, correct.
All right, well, let's try to work a resolution out. Let's see.
Okay.
There's been a rent adjustment, correct?
Yes, Your Honor.
Your Honor, can you explain what that means? I'm new to this. I don't know what anything means, and the rent mints and none of that stuff is, I don't know what it means.
Rent adjustment, your rent was adjusted from some amount to $484. I just saw it in the file.
To who?
What is your current, this is a complaint to terminate, this is a complaint to recover possession of property.
Yeah.
Yeah, the first paper I got was to move out the property by April 2nd because it was being sold. The second thing I got was a letter from the bailiffs or court people. She came and served me the paper on April 4th for eviction of property.
Okay, and now
for eviction of 1 month's rent, Your Honor. I got this the first letter handwritten by Mr. McGee on March 4th. It was in my mailbox, addressed to Vivian and occupants. And that was the first one I got for not paying a month's rent of February because Mr. McGee did not hold up the end of his bargain. He hasn't came back and did anything that he was supposed to do as far as fixing the house up, which he wrote on the lease that rent would be $950 until completed, and then rent will go up to $1150. We were in agreement with that. Mr. McGee has 16 citations against this house from the city of Detroit that the house is not even a Michigan rental property. The house was subject to foreclosure in 2018, 2019, and 20. And then I noticed that I'm just trying to figure out if he's losing the house to foreclosure, because I noticed that as of March, it was a certificate of forfeiture filed for the year of 2021. So I'm just trying to figure out, is this retaliation because I didn't pay rent in February because Mr. McGee didn't hold his end of the bargain up and continue to fix my house? Or is he selling the property? He told me he was selling this property, the property he owns next door, as well as the property across the street. The property across the street is listed on the market for $60,000 right now. But I don't see him messing with those tenants. So I'm just trying to see what's going on.
All right. And this is the notice states that property is being sold as you stated.
Yep.
Was there ever a lease?
Yes, I have the lease right here. It was signed December 12th.
Okay. And were there any breaches of this lease?
No, there's no breach on the lease that states if rent is missed, then eviction will be a case that's not on this lease, Your Honor.
Well, a non-payment of rent will be a breach of the lease.
Oh, it's not stated in the lease. That's what I'm saying.
Okay, but I just wanted to confirm that. All right. So how much time do you need, Miss? Sorry, I don't know your last name.
Broaden.
Okay. Yeah, Miss Broaden, how much time are you requesting?
I'm currently looking for a house. I'm applying to things, but you just gotta wait till they contact you back. So it's not that I'm not looking. I don't have a grudge against Mr. McGee. He could have just reached out to me and we could have talked about this and he gave me a certain amount of days, but he don't answer the phone. So yeah.
Mr. McGee.
Yes, Your Honor.
How much time are you willing to give Ms. Broaden?
June 1st.
Your Honor, I'm asking for 45 days if that's okay.
No, Your Honor, they've had ever since the March to move out. She's known that this has been coming. So I don't agree to 45 days.
45 days.
I had until April 2nd because you were allegedly selling the house. Treasury Department told me I had nothing to worry about. I didn't have to move until I was served court papers. And here we are today in court. So, Your Honor, I'm asking for 45 days to find another place for me and my daughter and my mom to stay.
All right. First of the month would be 21 days. Let's see. What's 30 days from May? All right. We're gonna do a judgment by hearing.
What does that mean, Your Honor?
It's a judgment. It's either consent judgment, default judgment, or a judgment by hearing. When parties agree, it's a consent judgment. When parties don't show up or a defendant doesn't show up, it's a default judgment. And the only thing left is when the judge makes a decision, it's a judgment by hearing. We're having a hearing right now.
Okay.
So, is there any objection to a removal of Ms. Broaden as a named party? Can this judgment go on all occupants, Mr. McGee?
No objection.
Okay.
I don't know what that means.
That means that this judgment will state all occupants versus Vivian Broaden and all occupants. So
Okay.
that means it may assist with finding some more housing. And the statutory time period that the court rules requires 10 days. He already offered June 1st. You're asking for 45 days, which is not going to happen, but I'll meet you all in the middle. And I believe 30 days, 31 days, June 12th. I'll enter a judgment for all occupants where all occupants must vacate by June 12, 2023, or writ can issue after that date.
So what if so we're not going by June 12th, Your Honor? That means like an eviction would be placed on my name?
It'll be placed on all occupants' name.
Oh, okay.
An eviction will be possible.
Okay.
Eviction could occur and could be filed after June 12th. So
okay,
you're good up until June 12th, but June 12th, then that's when all occupants will be at risk of eviction if it's filed, depending on the timing. So.
Okay. Thank you, Your Honor.
Welcome. Good luck, Mr. Gordon. Thank you for your. All right, thank you, Mr. McGee. You all.
Thank you, sir. Thank you, Your Honor.
You're welcome. All right, Attorney Phillips, Attorney Luan.
10 o'clock, 420.
10 o'clock, 420. Calling case number 2334-6420. This is Earl Buffington versus Sherry Kirsch and all occupants.
I'm here, Your Honor.
All right, and
Present.
who is that? Who just said that?
Earl Buffington.
All right, good morning, Mr. Buffington.
Good morning, Your Honor.
Good
Ted
morning.
Phillips. Ted Phillips,
Good morning.
P35900 for the defendant. Who is present? Ms. Kirsch, could you say your name?
Sherry Kirsch.
Your Honor, this is a termination of tenancy case, I understand. And we're asking for an adjournment to get a copy of the file. I would note that there was apparently a prior case which was dismissed and $5,000 was paid in March, paying rent through March. Defendant indicates she never received a notice to quit. There was an agreement when the $5,000 was paid that certain repairs would be made, including restoration of electricity, which has been out in the house since December of 2022, as well as a number of other repairs. Building and Safety has been contacted. We need time to get Building and Safety records. We believe this is in retaliation for refusing to pay April rent and contacting Building and Safety. And also there may be a park forest issue depending on when the notice is allegedly sent. Again, the defendant indicates she never received anything other than a notice on April 15th of a April 27th first hearing. And there was no notice prior to that as is required by law. I would ask for an adjournment. If available, I would ask if the 24th would be workable. I've got some other hearings that day that would just be convenient, but if that's not workable for the court, whatever the court chooses.
All right, Mr. Buffington, you have anything to respond?
Your Honor, yes, Your Honor. I have gone back and forth with with Sherry. This is about my fifth time filing on her. We did in January. She agreed she was 6 months behind. She agreed to catch up. I gave her a payment plan. She defaulted on April. She was supposed to pay, trying to catch up in March. She was supposed to pay me in March because she was behind. She didn't pay in March. I talked to her. She didn't pay in April. She did not pay in May. We've been going back and forth ever since she's been in the house. I probably have filed on her about 7 or 8 times. At this point, I just want possession of my property, Your Honor. I've just gone through cancer. I had a surgery. My doctor has told me I can't stress. I can't be in any stressful situations. And at this point, I want to sell the house. I just want possession of the property, Your Honor. I've just gone back and forth, and I'm just recovering from cancer. And I'm just, this is just stressing me out. I just want my property back and just be done with this.
Your Honor, briefly.
Sure.
Up until like 30 seconds ago, we seemed to be in agreement that at least that rent was paid through March.
No, there was no. She was behind. She was 6 months behind. She was going to make an extra payment in March. Then when I went to get the extra payment she was supposed to make, she said, no, I'm not going to pay. And that's when she broke the arrangement that she had made with me. I have it documented on a text message. She defaulted because if she would have paid, I wouldn't have evicted her. I wouldn't even ask for possession of property. But because she defaulted, she does this all the time. If you will check the records, Your Honor, I have filed against her about 5 or 6 times. She defaulted on a payment in March. And then when I went to speak to her, she was hostile towards me, got into a big argument. She left. I tried to contact her. She would not contact me. I asked if we had the rent. She would not reply. I have all of this on text message. And like I said, I'm going through cancer. I've just gone through this. I've got treatments, additional treatments to make. My doctors are telling me that stress is not good for cancer. And at this point, I want to sell the property, and I'm tired of going back and forth. I just want possession of my property. That's all I want at this point, because my health is more important than just going back and forth with all of these stressful situations. I just lost my father. I'm going through cancer treatment, and at this point, it's not worth it for me. I just want my property back. That's all. I've tried to give her a chance. I'm a minister. I've been trying to work with her, but at this point, there's no integrity there. And at this point, it's just not worth me, my health declining anymore with all of this. This is very stressful. I've got property taxes to pay. I've got a mortgage to pay on the house. I'm behind on I'm trying to catch up, and I just can't do it. I just want the property back at this point. Because
Your Honor, may I say something? This is Sherry speaking. The reason why he wasn't given that month in March, and Mr. Buffington should have that text message from me as well. As I went through my receipts, I did not owe him that extra $1,000. Yes, you do, Mr. Buffington, because we discussed this. And to my knowledge, he's not the owner of this property. He tells me he's the representative. He has other people that's invested in this property. And the reason why we keep going back and forth is because he won't fix anything up. That's honestly where that issue comes.
Your Honor, clearly there's a need to have an adjournment to get building and safety records. Ms. Kirsch previously indicated to me that building and safety was out within 3 days of when she complained. They only go out in 3 days if there's emergency repairs needed. So I would ask for a reasonable adjournment, a copy of the file, and a chance to get building and safety records. We can also check with the balances on the rent, but this is a termination case, not a non-payment.
All right, I muted both parties. Do a brief adjournment.
Does that work?
Yeah. Mr. Buffington, can you come back 22nd?
The 22nd?
May 22nd.
Your Honor, I've got to check. I know I have some doctors, some doctor visits. I've got to see exactly when that is. But I really want to resolve this issue, just to get the property. At this point, if I'm asking for possession of my property back, then I don't understand why I have, why we're going back and forth. If I just want the property, I don't want rent. I don't want any money from her. I just want my property back. I don't want any money from her.
Are you the sole owner of the property?
Yes, I am. And Your Honor, I came down to court 3 days ago and submitted the deed and the lease. And she's on a month to month. She's been on a month to month for over a year. She's on a month to month. Her lease is expired.
Okay, because the court doesn't have the file. That's another thing that I will.
I went down to court and I took the
Mr. Buffington, I have like 60 cases every day. And we have to do the document. As much as I want to hear every side of this, let's adjourn this. We'll be ready We'll have all the proofs. If you want to bring text messages and bring all your documentation, let's make a day. I'm here. I think if you're not available on May 22nd, we can pick another date.
I would like to go with May 22nd because I need to get this handled and get back into my treatment. Because I got to get back into my treatments.
Okay, and that's less than 2 weeks. So it'll be 2 weekends from now, that next following Monday. What time is best for everyone? 8:30 or 9:30?
Whatever works.
I
for the
like to
court.
do 9:30 works for me, sir.
That's fine.
Okay. Let's do
Your
May
Honor, did the court
22nd.
say that you do not have the file?
I'm sure it's here, but
Okay, we're going to be requesting a copy of it. I just wanted to be clear.
most likely in previous judge's courtroom.
Okay. All right. Thank you.
Okay, you're welcome.
What time is it, Your Honor? May 22nd, what time?
9:30.
Okay, now do I need to get those papers again or what? Because I submitted those papers.
Submitted it to the court. We'll have it. We'll
Yeah.
have it. All right. Okay, well, I'll see you back May 22nd.
Ms. Kirsch, you're all
At
set. We'll talk
9:30?
later.
Yes, sir. Good luck with everything. Good luck with your treatment.
Thank you.
You're welcome. Attorney Lawan and then Attorney Max Nicole.
Yes, Your Honor, I have a resolution on a 10 o'clock, 4247. Attorney Madden is not in the courtroom. She had to appear in front of Judge Kennedy, but she has given me permission to put the conditional dismissal on the record and to sign her name.
Okay. Calling case number 23344-247, Boydell Development Group versus James Below and all occupants.
Your Honor, Suzanne Stepich Lawan, P48702, Michigan Legal Services, on behalf of the defendant, James Baylaw, who is with us in the courtroom. Mr. Baylaw, can you unmute and state your name for the record, please?
James Baylog.
Good morning, Mr. Baylaw.
Morning.
So I am standing in for Attorney Hillary Braley. She and Ms. Madden have negotiated a conditional dismissal that the client has approved. It is a total amount due of $4,929. Defendant shall pay rent by the 5th of each month and an additional $300 per month by the 20th of each month until the balance is paid off. The above balance shall be paid off in full on or before October 1st, 2024. So long as defendant makes monthly payments timely, future late fees of the balance are waived. A courtesy email to defense counsel will be sent if the case is to be reopened in order to obtain a writ.
All right, what is the additional amount that's paid after the monthly?
$300.
Okay, so monthly rent plus 300, monthly rent is $950. Okay, so that'll be paid each month until $4,929 is paid.
And 4B is checked.
With a courtesy email, and do you have consent to sign for Mr. Baylaw? Baylaw.
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 Mr. Baylaw. There we go. Baylaw, gotcha. Mr. Baylaw, do you give Ms. Lawan consent to sign your name?
Yes, I do.
All right, thank you.
More
You have
people
any
have come
questions?
on. Twice as many people now have come on.
All right, the court is satisfied. Good luck. Attorney Madden was here earlier. I'll state for the record that she was here earlier and you have consent to enter this agreement without her presence.
Thank you, Your Honor. And Mr. Baylaw, you're done for the day, so you can sign off.
Thank you very much.
All right, Mr. Baylog. Attorney Mexico, are you and Attorney Fisher ready on your matter?
We're ready, Your Honor.
Calling case number 2334-6083. This is ID Capital LLC versus Gloria Dye.
Good morning, Your Honor. Andre Mexico, 7071, appearing on behalf of plaintiff.
Good morning, Your Honor. Janetta Fisher, P72872 with Michigan Legal Services, appearing on behalf of Gloria Dyer. Ms. Dyer, please state your name for the record.
Gloria Dyer.
Good morning, Ms. Dyer.
Good morning.
All right, were parties able to work a resolution out?
Yes, we have, Your Honor. At this point, we'd like to propose to the court a judgment by both consent and hearing, or it could be just by consent, whereby the named defendant's name will be dismissed out of the case. The rent to retain is $2,165, costs of $160, totaling $2,325, and the defendant to pay $675 by May 12th, 23, $400 by May 19th, 23, and the remaining balance, which is $1,250 by June 30th of 2023. Defendant further agrees to pay her June rent on time, and if defendant fails to make any of the amounts when due, an order of eviction shall enter.
That is correct, Your Honor.
All right, and is Ms. Dyer here? Dyer?
Yes.
And Ms. Dyer, do you give Ms. Fisher permission to sign your name on this conditional dismissal?
Yes.
Oh, I'm sorry, on this judgment. Okay, you know what? I thought this was a conditional dismissal. This would be entered as a judgment by hearing. It'll be a judgment by hearing. There's a removal of named parties where all occupants must pay $2,325. And the terms are as follows. $675 is to be paid by May 12th. $400 is to be paid by May 19th, with the remaining balance to be paid by June 30th. Meanwhile, rent shall be paid as normally scheduled. Is that accurate?
And you're one more thing, that the defendant fails to make any of the amounts that she promised to pay, an order of eviction shall enter.
All right, failure to fulfill these obligations or make these payments timely, eviction shall enter. So, good luck, Ms. Dyer. And we don't need to be MCR 4.201. You are represented by counsel, and we'll enter this as a hearing judgment because it's all occupants. So, all right, thank you. Thank you, parties. What'd you say, counsel?
I asked Ms. Fisher to text me her email address.
Okay.
I will do that, Your Honor. I will do that right now.
Excuse me, Judge, what was that date again? I'm sorry, I missed it.
That date was June 30th, Judge? June 30th, correct? The remainder is to be paid by June 30th?
Okay,
correct.
All right, thank you. Sorry about that.
You are. No problem.
Judge, do you have an April Jackson?
Chime in. You can always chime in, Madam Court Reporter. I have April Jackson.
Yes.
I have April Jackson with Attorney Horka. And do you have an attorney, Miss Jackson?
No, sir.
Do you want an attorney?
No.
Okay. Is Mr. Horka present in the courtroom? Did you speak to Mr. Horka?
No, I haven't spoke with anyone except my landlord agency prior to this hearing.
go. All right, well. In here is April Jackson, so people know you exist. And okay, well, sit tight, Ms. Jackson.
Thank you.
Well, you check in though. All right.
Okay, I just wanted to know if I was being heard today.
415. 38. Our party's ready. Attorney Dyer. Mr. Dyer?
Good morning, Your Honor. Ali Jagger, available judge. Congratulations. I haven't congratulated you on the appointment or the election yet, Your Honor.
Thank you. It's the election. I had to get petition.
It is the election. I apologize. I remember now.
Yeah. Our days at Home Depot and Meyer. Let's see. It's April Jackson. April Jackson, I know you're here. I saw you earlier. And we just spoke. Yes. I'm sorry. Anthony Adams. I'm sorry, Ms. Jackson. That was a mistake.
Yes. Okay.
All right. Have you all talked to? Do you all have an attorney?
No. No.
All right. Attorney Dyer is here with, I'm assuming, his client, but I'm going to put you all in the breakout room, see if you all can work out a resolution. If not, we can call your case. Unless you already have a resolution. Do you all have a resolution?
No. We just still in probate court with the house, but they told us that the house was still in probate court. The house is owned to the probate court until we go back. So the judge said that we are allowed to stay here because he is the oldest grandson. So I don't know what the court hearings is all about, because she knows that the house is not in her name. The house is not in her father's name. It's just in
This calling case number 2-334-6415. This is Michelle Jones versus Anthony Adams and all occupants.
Yes.
Good morning, Your Honor. Ali Jagger appearing on behalf of the estate, as represented by Ms. Jones. Your Honor, Ms. Jones is the personal representative of the estate of Jim Hodo. The letter of authority was issued by the court, by the probate court, allowing Ms. Jones to move forward with the eviction. A copy of the letter of authority was submitted as part of the case. Ms. Jones is responsible for the asset as the personal representative under the authority of the probate court to move forward. It's our intention, Your Honor, to vacate the home and then move forward to do whatever repairs necessary, and then move forward for the sale and the distribution of the proceeds from the sale. There is no order of the court staying this, of the probate court staying this. At this point in time, Your Honor, we're asking for a judgment allowing Ms. Jones to gain possession and otherwise dispose of the only asset of the estate of Mr. Jim Hodo Jr.
Good morning, Your Honor. This is Tom Parrish, P83642. I'm representing the Adamses on this case.
Okay. Good morning, Attorney Bershak.
Good morning, Your Honor. Could I have a chance to speak with the Adamses and we can recall this one?
Absolutely. Okay. Yeah, we'll recall this, and I'm trying to track down the file in the meantime. So, all right, and parties, you all know each other exists. So everyone has breakout privileges. Mr. Bershak, if you want to invite counsel into a room after you speak to your client.
Yep.
I'm sure he will.
That's the plan, Your Honor. Thank you.
You're welcome. All right. Sit tight, counsel, and we'll recall your matter.
Thank you.
That goes for you as well. Bershak is going to talk to you all, and then go from there. It's such a benefit where you have an attorney, You don't even know you have an attorney.
Oh, yeah.
That's amazing. Beautiful thing.
Excuse me, Judge. I've posted in the chat a couple of times. I'm trying to find out if there's an attorney from Pallets that's present in the Zoom.
Mr. Marchese was here.
Okay, thank you.
Let's see. Are you looking for on the Jessica Cousins case?
I am, Judge.
Yeah. I don't know. Are you assuming that's a dismissal?
Well, I was going to try and talk to the attorney, but that was scheduled for 10 o'clock. It's now 11:20, Judge.
No, because usually, I know, starting to get the flow of all of these attorneys, and he's one that doesn't really put his dismissals on the record. And they usually file, and in the file, it looks like dismissal without prejudice was filed, and the pleading is ready for court pickup. So let's call this case because my suspicion was confirmed. This is a dismissal without.
Okay, Judge, thank you.
I'll let you do the motion and get the credit.
That's fine, Judge.
Calling case number 2334-6384. This is Detroit City Club Apartments versus Jessica Cousins, Michael Cousins, and all occupants that may or may not be cousins.
Good morning, Your Honor. Robert Santiago, Michigan Legal Services, P57157, on behalf of Michael Cousins, who is present in the courtroom. Michael, can you please state your name for the record?
Michael Cousins, Your Honor.
Thank you.
Judge, at this point, this matter was scheduled for 10 a.m. It is now 11:22. I am asking that the matter be dismissed without prejudice.
This matter is dismissed without prejudice. Upon motion of defense counsel, and I believe there is a dismissal in the file. So granted, Mr. Santiago.
Thank you, Judge.
You're welcome.
Take care, Michael.
Could I talk with you in the break room?
Yes.
Thank you.
All right, is Ronald Watson here? Ronald Watson. Do we have Ronald Watson? Do we have Gregory Carter?
Good morning, Your Honor.
Your Honor. Attorney Frank Cassie, good morning.
Good morning. How are you?
Doing well. You've been patiently waiting. Are you representing Gregory Carter?
I represent the estate of Deloyes Carter.
Okay. And have you had an opportunity to speak to, I don't know if Ms. Alba is in here, it looks like Ms. Calabat may be handling those cases?
I am here.
Good morning.
Good morning.
Ms. Fracassi?
I did not realize that she was here from Trot and Trot, and I do know that Gregory Carter, who's also here on this call, has been trying to buy this house. He's been speaking with Mary Cross at Trot and Trot.
Okay, so I'm gonna put you all in a breakout room, and I think that it would be beneficial. Someone toss a hand up when you're out of the breakout room, and I'll call the case.
Okay, thank you, Your Honor.
A digital hand when you do toss it up. Okay. All right, so let's see if you have privileges. I'll give you breakout privileges, Ms. Calabat. Is it Calabat?
Calabat.
Calabat. All right.
How do I get to the break room, sir?
All right, Mr. Carter, I'm going to invite you to a break room and you'll see a prompt on your screen.
Thank you.
You're welcome. Let's see. We have to get breakout first. Alphabetical order by first name.
Hello, Judge. My name is Trisha King. I'm sorry to bother you.
Oh, Mr. King.
They put me in a breakout room and I was there for a while, just making sure that I wasn't supposed to be here or over there.
Sabree can only do one thing at a time. And I'm occupied with filling up breakout rooms and I'll talk to you after that. So I just forgot which room I put everybody else in. All right, room 12. Mr. Carter, you have a prompt to go to room 12. And then
Judge, did you just call Mr. Ronald Watson?
I don't believe so. Calabat, it's Calabat. Where are you? I need you to go to room. Okay, you've been invited into room 12 and then I need to get the attorney in. Oh, okay. There we go. That's my issue. Hit meeting rooms and you should have that join. There you go. All right, Ms. King, what were you saying? Ms. King? You just asked me a question. Now I have time to answer the question. All right, Ms. Carey.
Yes, Your Honor. I just wanted to let the court know with Ms. King, we are not, she does not qualify for our services. So if she wanted to speak with the plaintiff, they can be put in a breakout room. She's not waiting to speak to us. I just wanted to clarify.
Okay, all right, thank you. Ms. Patricia King.
Ronald Watson.
All right, Orangelo, good morning. Ms. Max Faulkner.
Yes, good morning, Judge.
Do you need to speak to Ms. King or have you all had a
I'm sorry, I can't hear that good. No, we have not had a conversation, and I actually prefer not to have a conversation with Ms. King because I am selling the house and I have reached out to her multiple times, and plus what happened in the past with her in the house, along with her son forging my signature on a lease on a lease agreement.
What? My son did what?
All right. Call. Let's see what parties are. Any other parties?
Your Honor.
All right. I'm gonna hold off on calling this case right now.
Your Honor, this is Ronald Watson. You called me. Your Honor.
Yes, I hear you, sir.
Oh, okay. Just making sure. Just making sure.
All right. Mr. Ronald Watson.
Yes.
I have you checked in. Do you have an attorney?
Yes.
Who's your attorney?
Tom.
Fair shot. Okay. All right. Mr. Bereshai, notify me when your case is ready to go. Okay. All right, so I'm gonna place you on the Aldridges, and then I'll get to Miss Max Faulkner King. All right. Ms. Lawan is ready. He's in room 6 right now. All right.
Hi,
Your Honor. This is Kelly Miller. I was in a breakout room, but I was not able to unmute myself. I unmuted myself, but the person I was speaking with was still unable to hear me, so I called back. And I've been on this phone call since 8:25, so I just wanted to see if I could get back to the breakout room, please.
Okay, I'll put you, are you talking to legal aid?
I was, yes.
All right, I'm gonna put you back. Put you in the breakout. Gloria Dyer.
Yes, I was actually just wondering if I still needed to be here.
Were you on the, no, you're free to leave. You're on Attorney Maximkov's case. You're free to leave, Ms. Dyer. You may go.
Okay, thank you.
Have a great day.
Thank you.
Well, is the Christian Lockhart here? Is Kyle Miller here? Okay, I have Christian Lockhart. Christian Lockhart, are you waiting to speak to the plaintiff's attorney?
No, I already spoke with him.
I can't hear what you said. Can you speak
Yes,
up?
I already spoke with him in the breakout room.
Your attorney or the plaintiff's attorney? Or the
Yeah.
landlord?
The landlord attorney.
Okay, you all are ready. Are you ready for your case to be called?
Yes.
Okay, I have to wait for Attorney Worker to get back, but if you put your hand, are you down there? No, put your hand up in the chat and then I won't. If anybody has anything ready, just put your hand up like Ms. Lockhart did in the chat. I'll call it. Mr. Barishaw, you have anything? Yeah, Ms. Jackson, it's a little digital gesture button on there.
Okay, can you hear me, sir? Your Honor?
Yes, I can.
I've been here since 9:30 and I don't know if I was supposed to talk to someone or not, or if you was just supposed to hear my case or anything. I'm just here because they said, okay, I'm listening.
The attorney for the landlord is not here. And I need him to see, I need him for you to talk to him. And see if you have representation, I need that person who's representing you, that attorney, to talk to him. So that's really the holdup.
I didn't have an attorney. I did speak with the management company last week regarding payment arrangements, and I just spoke with the specialist from DHS for the SCR. They did approve it, but they won't release it until I pay my portion of it. And I told Kelly that she could take payment, $200 payments out of my monthly income that's going straight to the bank. So I was just waiting to talk with someone that I needed to talk to. I spoke with the management company, and that's how that's going. It was a judgment for $1,700. They're gonna pay $279, and I paid $1,300.
Okay.
So I haven't talked to any attorney. I just spoke straight to the landlord's management company.
Okay.
Yeah.
All right. Well, Attorney Morgan has to come back.
So do I have to continue to hold, Your Honor?
Yes, please.
Okay, I will hold.
I wish I could get you out of here faster, but
That's okay. Everybody has a job to do.
I appreciate
Just trying to
your
keep me and my grandkids' head above water.
That's the goal every day.
Patience.
Your Honor,
Yes.
I'm an attorney on a case. I've been here since 10 o'clock. I just want to see if we're on your docket for sure.
Is Sharon Taylor here?
Yes, Your Honor.
All right. have you and Attorney Rubin spoke?
Your Honor, we know each other, and I'm here because I want to ask for adjournment. I asked to adjourn this at the original hearing with Judge Kennedy, but I had to have this date. And we talked to your clerk, and Curtis said that I should just appear and ask you. This is out of an estate. There's a lot going on, and I want to file appropriate pleadings and ask for, trial. And that's why I'm asking for an adjournment, so that I can prepare the proper pleadings to represent my client. Ms. Taylor and my client are brother and sister, and there's a lot going on here that I think that the court needs to know about, and so we can have a fair hearing for both. So I was.
Your Honor, I'm sorry, Your Honor.
Well,
hold on. Let her finish her sentence, and then I'm going to ask a question, Ms. Taylor.
Thank you. Thank you.
Is there an ongoing probate?
I'm sorry?
Is there an ongoing probate matter right now?
Probate matter is now over, but my client was awarded in the will a life estate in the upper flat of this property. And my lived there for 30 years. As I said, they're brother and sister. He lived there with his mother.
All right. Okay. So
I, for 30 days, just so I could apprise the court, ask for, a proper hearing, a proper trial, and let the court go on.
All right, Ms. Taylor.
Yes, Your Honor. This case has been going on for almost 2 years. The will was admitted into court based on probate court. The will, as Attorney Rubin said, that it gave my brother life estate in the upper flat. However, once our mother passed, my brother relocated to the lower flat. So that's what's in question right now, having him move from the lower flat to the upper flat. I have not been able to get into the lower flat to take care of my mother's belongings or as representative to take accounting because he is not willing to allow me into the home as well.
Okay, this sounds like something that can be addressed today.
Yes.
Ruben, why can't we address the lower flat issue today?
Well, Your Honor, my client has never resided in the upper flat. It is uninhabitable. He has never lived up there. He's always lived with his mother downstairs. He did go up.
I just had to cut you off.
Yeah.
Does he have a life estate in the entire house, or is it just the upper flat?
I didn't hear, Your Honor, what?
Does your client and Ms. Taylor's brother, does he have an interest in the lower flat, or is his interest solely in the upper flat?
Well, his interest by the will is in the upper flat. However, the upper flat is not habitable, and we would argue that because he has a life estate and he has been paying utilities, etc., and other things, taxes, utilities, that he should not be evicted from the home that he's lived in for 30 years.
Okay, but he doesn't have, all right, so I'm going to set a brief adjournment. We're going to keep this in May. And I'm setting this adjournment really for the purpose of utilities and bills, to make it a clear understanding of what would be paid if one person is occupying a portion of the house and not all of the house. Because if I were to grant an eviction or make a decision today, I'll still be missing a little bit of information on what and how parties will just be able to function splitting a house up. Is the house split up?
Yes, yes, Your Honor. There are two separate residences and each portion has its own utilities. The only thing we share is the water. So each flat has its own furnace and hot furnace and own electricity. So there are separate bills for both.
That's all. That's all. A lot of it. Okay. Well, Attorney Rubin.
Yes.
Can you come back the week of May 22nd?
On the 22nd, is that the date?
The week some day that week.
I have Monday available, the 22nd.
Okay. Let's come back at, let's see, May 22nd will work at 10 a.m.
Also, Your Honor, may I say one more thing?
Absolutely.
I have been paying the taxes and the house insurance on the property, but we received a notice of cancellation because of abandoned cars in the backyard. So the insurance company canceled the property insurance. So I am asking that his 3 abandoned cars be removed so that I can place insurance back on the property again.
And I am not sure that there isn't insurance on the property by my client paying, because there have been double billings and double utility payments, double insurance.
We'll address all of this in a week.
Right.
About a week and a half. Thank you for making me aware of this, Ms. Taylor. If there are pending issues, but we'll have a resolution on the 22nd. And doesn't seem like it's going to be too difficult to make this decision, considering that's been presented. So I'll see you all back. Ms. Rubin.
Yes, Your Honor. What time on the 22nd? I didn't hear a time.
Let's say it's 10 o'clock.
Oh, 10 o'clock is fine.
All right, let's do 10 o'clock.
Thank you, Your Honor.
You're welcome. And this is case number 2334648. I'm not sure if you actually called that case.
648. No, we didn't.
What happens when people start before we call the case?
Oh, yes, it does. It happens. I didn't know I was on it.
All right. ISREMP. All right, Mr. Horka. And Ms. Calabat, I'll call you after Mr. Horka.
Okay.
Jasmine. Is Jasmine Jones here? Yeah. Calling case number 233460755 532 Tidalway LLC. Jasmine Jones and all occupants.
Good morning, Joe Horka, P75969, appearing for the plaintiff.
Jasmine Jones here. Judge, I do have to say that she gave me a call and she said she was zooming in. That was about 15 minutes ago. All right, let's hold off on that default. Counsel, you have anything ready? You have one with Lockhart?
I do. Miss Lockhart and I are ready.
Okay. Calling case number 2. There's Jasmine Jones. Timing. Calling case number 2334610. This is 532 Tidalway LLC versus LaChristian Lockhart.
Good morning, Joe Horka, P75969, appearing for the plaintiff.
Thank you. And Mr. LaChristian Lockhart, can you state your name for the record?
LaChristian Lockhart.
Thank you.
I know we spoke in a breakout room. I believe we have a resolution on this matter. Ms. Lockhart has a current balance with rent and court costs of $7,763.32. She's just got a few items left in the property. She'll be moving out in the next couple days here. We'd like to do a conditional dismissal. Box 4B, May 22nd is the move out date, or pay or move out date.
All right, is that 7763.33?
Yes.
All right. The conditional dismissal. 4B will be checked, which means a judgment and a writ of eviction can issue at the same time in the event that Ms. Lockhart, you don't vacate or pay $7,763.33 by, what was that date, Council?
May 22nd, please.
May 22nd, 2023. You have any questions, Ms. Lockhart?
So this won't be on my record?
If you vacate by May 22nd or pay $7,763.33, this case will be dismissed. If you fail to vacate or fail to pay by May 22nd, a judgment will be on your record and a writ of eviction will be issued.
Okay, so just to be clear, so it's either I pay or either I evict, right? I mean vacate.
Either pay or vacate,
Okay.
and nothing's on your record, case is dismissed, but that has to be done by May 22nd, or don't do anything, get a judgment, and get evicted, I guess.
Okay, got it.
Okay, all right, any other questions?
Just for my end.
Okay, do you give Mr. Horka permission to put your signature on the conditional dismissal?
Yes.
Okay, all right, the court is satisfied. Thank you, parties. You are free to go, Ms. Lockhart. Take care.
Oh, have a good one.
All right, you too. I think there was somebody, let's see, okay. Mr. Horka, where'd you go? April Jackson is here. I believe she's ready to speak to you.
Tried to invite her into a breakout room, but didn't have any luck.
All right, Ms. Jackson, I need you
Yes,
to.
sir. Yes, sir.
I need you to accept the breakout room invite. I'm
Accept
inviting
the breakout room invite. Okay.
room 7, and I'll just move you to room 7, Mr. Horka.
So it say join.
And Mr. Horka, I sent you a message about the last case we talked about.
Yeah, I see it. I'm just waiting for my client to chat me whether they accept.
Perfect, thank you.
Ms. Calabat,
Yes, Your Honor?
are you ready on the matter?
Yes, I'm ready. On quite a few, actually.
Okay, is this the 397 or do you have some defaults?
Well, let's start with the 397. I do have 2 defaults, and one I'm confirming that you got the conditional dismissal, and another we have a consent judgment. So
All right, sounds like you have it figured out. Okay, calling case number 2334-6397, Cascade Funding Mortgage versus the estate of Dolores Carter and Gregory Carter.
hello, Your Honor. Jasmine Calvert appearing on behalf of plaintiff P82755.
Good morning, Your Honor. Jennifer Fracassi appearing on behalf of the estate, P45651.
Thank you, counselors.
And Gregory Carter is also here.
Hello, Mr. Carter.
Hello, sir.
How you doing? All right.
I'm doing.
All right, doing. Got some good weather. Stay positive. Okay. Do parties have a resolution in this matter?
Well, Your Honor, the parties have made an offer to purchase the house and they have not gotten a response back. So while they're waiting for a response, we would like a 30-day extension.
Okay.
Your Honor, I would be clear that my clients prefer mainly to get a judgment with, and we can dismiss all named defendants with a 30-day vacate day and waiving the 56-day rule. I explained I don't see them accepting the repurchase. I'm still waiting to hear back, but I do think it is more than unlikely. And I think within 30 days of the repurchase, and 30 days vacant, it just seems unnecessary to come back for another hearing if we can do it that way.
And what's the 30 days? Why is 30 days the number?
Well, I only have authority to do vacate for 30 days.
Oh, no, I was just.
Your Honor,
Why?
when we were talking to the attorney, she told us that the offer was probably a couple $1,000s too low. So they're going to make another offer today, and they are very, they would really like to stay in this property and keep the property in the family. So we need some time to now make that offer. Gregory Carter, got an understanding of the offer that needs to be made. So we would like to come back in 30 days. And
I can't give you 30 days. Because he can make the offer. Nothing's stopping Mr. Carter from making the offer. If this, this is really, it seems like trying to buy time, but.
Well, but they haven't gotten a response to us, from the earlier offer. So that's not fair that we have to sit and wait for an offer while the clock is ticking.
Yeah, you just told me that the other offer was denied, correct?
No, it has not been denied. We haven't gotten an answer back. The attorney said it may get denied, but
I made it very clear that anything less than the sheriff's seat is going to be denied, and that was what the offer was.
But we have not gotten a response from the offer.
All right, do you have authority to accept and deny offers, Ms. Calabat?
No, I do not.
Okay, but you just stated that the offer would be denied.
I know with the history of our client in this type of mortgage that anything less than that sheriff's seat is guaranteed to be done, but I do not have the authority to deny it myself, which is the history of our clients. They want to make another offer for the sheriff's seat more. I will take that back. I cannot make any promises on whether they will accept that either.
Has a new offer been made?
Well,
not at this time, Judge.
Not officially.
But we haven't officially gotten a response from the other offer.
Okay, so.
Your Honor, may I speak, please?
Sure.
If they refuse the 46, I would know to go higher, but it would be advantageous for me to offer 51 and they haven't refused the 46.
That is accurate. We haven't formally gotten a rejection, so we should wait to get a rejection and then we'll offer a higher amount. So it would only be fair to give a 30-day extension while we're waiting for them to formally respond.
I'm not putting anything out for 30 days. I'll adjourn it, and if parties are still in negotiations, I'll adjourn it again. But if parties are in negotiations with Cascade Funding, which everybody seems like they are, then I'll set it off for a second.
Okay, thank you.
What was that date?
May 22nd at 10 a.m.
Thank you.
Is it still will be before you or?
It'll stay in this courtroom.
Okay, thank you.
So, all right, well, good luck, and if not, then I know what the plaintiff is requesting, and I know what the defendant is requesting, so hopefully there's some progress. If there's no acceptance of the first one by the next hearing, then obviously, it's not gonna move.
Your Honor, I have a full morning that morning. Can we do it on the 23rd, May 23rd?
Let's see. Yeah, we can do it on the 23rd.
Okay, 10 a.m. on the 23rd.
That works. Does
Okay,
that work for you? Ms. Calvat?
We'll make it work.
okay,
All
thank
right.
you.
That's the spirit.
Hey, and Your Honor, I'm ready with
Thank you.
Attorney Tom on 6394.
Calling case number 23346394. This is Fannie Mae versus Ronald Watson and all occupants.
Hello, Your Honor. Jasmine Calvert appearing on behalf of plaintiff P82755.
And good morning again, Your Honor. Tom Barashai, P83642 on behalf of Ronald Watson, who's with us. Ronald, could you state your name for the record?
Yes, this is Mr. Ronald Watson.
All right, so parties able to work out some type of resolution?
Yes, Your Honor. We have agreed to enter into a consent judgment with the vacate date of June 30th. We are dismissing all named defendants, it will only be against all occupants. And we would like to waive the 56-day rule. I've submitted that to opposing counsel, and do I have your permission to sign?
I've not had a chance to look at it, but yeah, if those are the terms of there, you can sign on my behalf.
No problem.
Your Honor, Mr. Watson has also given me permission to sign on his behalf.
Okay.
Yes.
All right, thank you. The court is satisfied, and this is the termination of tenancy, so there's no conversion. Consent judgment will be entered as to all occupants. There's a waiver of the 56-day rule. All occupants will vacate by June 30th, or a writ may issue.
Thank you, Your Honor. Thank you, counsel.
Thank you. And Tom, before you leave, we had another one with a conditional dismissal. I have not received the signed judgment, Your Honor. It's ending 6395. Tom, I don't know if you received the signed dismissal.
I don't believe I have, but I think the court removed it from the docket, so I suspect it's been entered, but the ROA is down, so I can't confirm.
Yeah, I think it's entered because it's not on my ROA, and based on my experience, I would say that it's dismissed.
Okay, no problem.
Your Honor, would you like us to resubmit it just in case, or are you confident that it's been entered?
Pretty confident it's been entered.
Okay.
And then, Your Honor, I had two others 10 o'clock, and I have not heard from anyone. One is 639A, and the other one is 6399.
Does anyone live at 18975 Sussex Street?
This is unfinished short from Your Honor. Mr. Watson, everything finished?
Mr. Watson, we just handled yours, so you can speak to your attorney, but I think we are done.
Oh, okay, so everything is okay?
Yes.
Everything's okay?
Okay, so I can take the Zoom off.
Yep, you're free to go, Mr. Watson. If you have any questions, give me a call this afternoon, okay?
Okay, thank you. You have a blessed day.
You too.
You too.
All right. Is anybody at 18975 Sussex? All right, calling case number 23346398. This is Federal National Mortgage Association versus all occupants at 18975 Sussex Street. May I have a appearance?
Hello, Your Honor. Jasmine Calvert appearing on behalf of plaintiff P82755.
Thank you. Does anyone reside at 18975 Sussex Street? Sussex. No one has responded to
Hello?
the court. Yes, Ms. Davis?
Yes, I'm here. Can you guys hear me?
Do you live on
I'm sorry. Give me 1 second. My connection is having a little. Can you hear me, sir?
Yes. Do you live on Sussex?
Nope, not Sussex, Manning.
All right, hold on 1 second. We're in the middle of a hearing. regarding Sussex.
Okay, sorry about.
That's all right. So no one's at 18975 Sussex. Our counsel, defendant failed to appear. Are you requesting a default judgment?
Yes, Your Honor.
Termination of Tennessee case. Is there a preferred move out date?
We'll do 10 days, which falls on a Sunday. So why don't we do May 22nd?
Parties must vacate by May 22nd or a writ may issue. All right, that concludes that matter.
Okay.
On case number 2334-6399, this is PNC National Association versus Sherelle Powell and all occupants on Wisconsin.
Good morning, or hello, Your Honor. Jasmine Cabot appearing on behalf of plaintiff, PA2755.
Good afternoon. Good afternoon. Is Sherelle Powell here? All right, defendant failed to appear, counsel.
And we would like to enter a default vacate day, May 22nd also.
Default judgment is granted. Defendant failed to appear today. I mean, the time of the hearing was set for 10 a.m. No, I believe it was, for 10 a.m. It's now 12 p.m., 12 o'clock p.m. Default judgment was requested. It's granted. It's a termination of tenancy case. Defendants must vacate by May 22nd or a writ of eviction may issue.
Thank you, Your Honor. That concludes all my cases. You have a wonderful day.
All right, you too. Take care.
Bye.
All right, let's see, Ms. Davis, you're at 298.
No, I'm at 15006 Manning. I'm the actual landlord.
All right, is Sharday Reed here? And Attorney Phillips, I'll call you shortly. Is Sharday Reed here? All right, calling case number 233-44298, Mariah Davis versus Sharday Reed.
Yes, Sharday Reed is here. I'm in the breakout room right now speaking to what's your name, ma'am?
Okay, I'm gonna recall this case and then please let us know when you're out of breakout room.
Okay, thank you.
ISREMP. Attorney Phillips.
You had an 8:30 case, I'm told, it ends in 626. That was not on the courtroom calendar. I didn't see the gentleman until about 11:20. I don't know if I'm not sure who's on the other side. I think Mr. Bajani was. I've tried to call him. I don't know whether it may have gotten just defaulted or not called yet or what. It's
626.
Yeah, 2334-5626. Kenneth Lewis is the defendant's name. Regarding property at 7611 Weatherby. It was apparently adjourned from May 4th to today. Why I assume it didn't make it on the docket.
Oh, Luke's Property Management.
Yes.
Okay. Let's see.
Do you know if that was called already or?
I didn't call it yet.
Okay, all right. We're going to be seeking an adjournment for what it's worth.
All right, is anybody covering Bajani's cases today?
Okay, I'm back in front of the judge.
I'm gonna meet you, Ms. Jack. Calling case number 233456626, Luke's Property Management versus occupants at 7611 Weatherby, including Mr. Lewis.
Afternoon, Your Honor. Ted Phillips, P35900 for the defendant Kenneth Lewis, and who is present. Mr. Lewis, could you say your name?
Mr. Lewis is coming out of the breakout room.
Oh, sorry. Mr. Lewis, could you say your name?
This is Kenneth Lewis.
Thank you, Mr. Lewis.
Your Honor, I believe this is a termination of tenancy case, but Mr. Lewis has indicated that he was purchasing the property. He has some written documentation in the form of text messages and maybe emails. I would ask for a adjournment for us to have time to pursue that. And I will, could the court confirm, is it Mr. Bajani on the other side?
Yeah, Mr. Bajani is attorney for.
I will contact him. I did try to call both his cell and office, but I didn't hear from him yet.
Let's see, can we confirm, let's see if this matter is still. Okay, 233456626. Two, three, three, 4, 5, 6, 6. Case scheduled to today, 9 o'clock. Or maybe it's still here. Mr. Bajani is still on it.
Well, I would ask for May 25th or the following week as an adjourn date. And we need to get the file.
Okay, I'll leave the file. All right, I can meet you back May 24th at, let's do 10 o'clock a.m.
Yeah, can we make it the 25th? Just to make sure I see you both days. I was being facetious, but 25th, is that okay?
Yeah. All right, we can do the 25th. We can
Yeah. Okay, thank you.
Go back to back. All right. I see 10 a.m. on the 25th. Can't wait.
Mr. Lewis, I'll give you a call this afternoon. You're free to go.
All right, Mr. Lewis, free to go. Good luck. 5626. Is Dominique DeShazo here? And then Sharday Reed.
I'm still in the break room. She's doing a questionnaire. Christine, I believe her name is.
She also was
Oh,
adjourned to the 24th, I believe, Your Honor.
Shazo was adjourned to the 24th.
Right, at 9:30. That's what my record showed.
Thank you.
Your Honor, is it okay if I move Miss Reed? It looks like she's on 2 devices. Can I just move her into the breakout room where she's talking to someone?
Please, absolutely.
Thank you.
Stephen Carter here. April Jackson, are you ready to go on your matter with Attorney Cox?
Yes.
Okay, it looks like, with Attorney Horka. Okay, he's in room 10. So probably after he's out of room 10, I can call your case. And then we'll get you out of here. Almost there, almost at the finish line, Ms. Jackson.
I hope so for my sake.
Your
Party
Honor.
break.
Oh,
Anthony,
yeah.
go ahead, Mr. Juan.
I was just gonna say, we also have all the parties here for 4390, where you wanted a report on our research. I was just gonna ask, do you think we're gonna be able to do that before lunch today, or should we just ask the parties to return?
Let's do it before lunch and Ms. Dyer, Mr. Dyer, are you ready on your?
Your Honor, as far as I know, we are. I can't pronounce his name. Is it Barishaz? Hopefully he's on now.
Sam.
There he is. Okay.
Okay. Yeah, I think we'll be able to do both of these. All right, Attorney Burke, are you ready on? What is this? I can't.
It's 233464115.
Yeah, Michelle Jones and Anthony Adams.
Ready when the court is, Your Honor.
Calling case number 23346415, Michelle Jones versus Anthony Adams and all occupants.
Good morning, Your Honor. Ali Dagger appearing on behalf of the landlord in this matter, the estate of Mr. Hodo.
I get that bitch get hit by a truck.
Ms. Adams, please remain muted.
Yeah, because that's pretty easy. All right. Let's see.
Your Honor, this is the time and date set for the hearing. And at this point in time, I'm requesting that the court issue a termination of tenancy.
Your Honor, the defense objects. As Mr. Dagger stated, he represents the estate, but the plaintiff in this case is Michelle Jones as an individual, and so we don't believe she's the proper plaintiff here.
Not true. If you review the pleadings, he is the personal representative of the estate of Mr. Jim Hodo Jr., sir. Those are the pleadings.
And what was this matter before we arrived in this courtroom? Where were you all before this courtroom? What court? Judge Kennedy's court before?
Correct, Your Honor.
Yes, it was, Your Honor.
Probate court.
All right,
Ms. Adams, please remain muted until either I or the court addresses you.
Your Honor, the proper party is the personal representative. And in fact, that's who's brought this complaint. I've been able to forward to counsel the letter of personal representation that was issued by the probate court. Counsel had an opportunity to review it. Now, we've also forwarded that same letter to the court, and it was delivered to the court based on our tracking on April 24th. My client is the estate, and therefore they're the proper party. We ask that this court issue the termination.
All right. We're gonna have to put this off into the afternoon because I have to locate this file. I believe it's in Judge Kennedy's courtroom. I want to review these documents before I make a determination. And I hate to hang you guys up for another few hours, but if we come back at 1:30, I can probably make a determination, but I'm not doing it without a file. So you all want to come back after lunch? It's your pleasure, either after lunch or a brief adjournment, whatever you like to do.
We'll come back after lunch, Your Honor.
I'll be here, Your Honor.
Okay. All right. I'll see you all. Sorry for the wait, but that's how it works sometimes with so many cases. So
Your Honor, just one last, if we can get counsel to at least acknowledge that these are the proper parties and provide me, I don't understand why you think this is not the proper party.
I'm not certain. I don't unfortunately have a copy of the pleadings in front of me. I'm
So
in
you
the same
made a
situation as the
statement-
judge.
You made the statement without reviewing the pleadings?
What I do have in front of me is a copy of the Register of Actions, and it only lists Michelle Jones as the plaintiff. Again, not the estate. When you gave your appearance, you said you were here representing the estate. And so I think there's some determination to be made about that.
And so, all right, thank you. See you at 1:30.
You're welcome.
145.
I'm sorry?
145.
Thank you, Your Honor.
I think I may go over. I'll try to knock out as much as possible this morning. So we may stop at 12:45 instead of 12:30. So 145.
Thank you, Your Honor.
You're welcome. All right, Mr. Horka.
Should have a few ready, Your Honor.
All right, I'm ready when you are ready.
461, please.
Calling case number 2334-6461. This is Go-To Guide Property Management versus April Jackson. Your time has come, Ms. Jackson.
Thank you.
Good afternoon, Joe Horka, P75969 for the plaintiff.
Good afternoon. And Ms. Jackson, can you state your name for the record?
April Katrina Jackson.
Thank you. All right, were parties able to work out some type of agreement or arrangement or resolution?
I believe we have, Your Honor.
Yes, sir.
Okay, let's put the terms on the record. What are the terms?
Your parties would like to do a conditional dismissal with box 4B checked. The total of rent and court costs is $1,907.50. Ms. Jackson and SCR will pay a total of $1,579 of that by June 1st. My understanding, Ms. Jackson will pay $1,300. SCR is good for $279. That leaves a remaining balance of $328. She's going to make 3 installment payments on that beginning in June of $110 by June 10th, July 10th, and August 10th until that balance is erased.
Okay, June 10th, July 10th, and August 10th. To the balance. And those are 3 installments of $328?
Yes.
3 installments totaling $328. So each installment is $110.
Okay. And what's your monthly rent?
$1,150.
And that's
So
paid,
that-
Your Honor.
And you
This
said
is
that's
not, this is for, I've been here 7 years. This is for the first month of security, which I was not asked for when I did my lease and got my key. But, hereafter they did ask for it, but things happen. I lost my income, but, I got my income going back again in November, which is $914 a month. And I have custody of my 2 grandkids who I don't get any help with. It's just me and my babies. I'm doing the best I can.
right. Okay. So I asked that because I didn't know if the monthly rent was in addition to the was it the 114 or the?
No, my rent is paid on time every month because I get Section 8.
Okay, so we're not out this balance.
And
Gotcha.
that's it.
All right, and does Mr. Horka have permission to sign that, Ms. Jackson?
Yes, he does.
All right, well, the court is satisfied with this conditional dismissal. Upon satisfaction, your case will be dismissed. In the event that you reach this agreement, there's a possibility of a judgment and a writ of eviction.
Well, pray for me, Judge, that I'm able to do this. I do have some grit.
Okay, all right. I have confidence in you, Ms. Jackson.
Okay.
And good luck. We'll pray for you. And that concludes this matter. Court of
Thank you.
condition. All right, you're welcome.
Have a good day.
All right, you too.
We are ready on 495.
On case number 23346-495. That's 532 Tidal Way LLC versus D'Angelo Mallet and all occupants.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Good afternoon, Suzanne Stepich Lawn, P48702, Michigan Legal Services on behalf of the defendant D'Angelo Mallet, who is with us in the virtual courtroom. Mr. Mallet, could you unmute and state your name for the record, please?
D'Angelo Mallet.
All right, Mr. Mallet. Are parties able to work out an arrangement?
Our parties would like to do a consent judgment as to all occupants only, converting the matter from a non-payment of rent to a termination of tenancy, with June 9 as the move-out date.
June 9th. This is a termination. This is converted from non-payment to a termination case where defendants agreed to vacate by June 9th, 2023, or a writ may issue.
That is correct.
All right. Is this okay? All right. Court will enter this judgment. Is this still in Mr. Mallett's name?
I was okay with it being against all occupants, Judge.
I was just asking. Either way. It's counsel, Mr. Juan.
I'm so sorry, Ms. Smith was calling me to see where we were. What was the question?
Let's do a hearing judgment. We'll do a hearing judgment.
Okay.
It's converted to a termination of tenancy case where all occupants must vacate by June 9th.
That is acceptable, Your Honor.
Okay. All right, is that acceptable, Mr. Horka?
It is.
All right. That concludes that matter. And 6495, is Elijah Avery here? What about Shanika Moore? Calling case number 23346-470, that's City Living LLC versus Elijah Avery and Shanika Moore.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff.
Good afternoon. I don't hear anyone responding to the call of the court by the name of Elijah Avery or Shanika Moore. So counsel, you may proceed with whatever motions that you have for the court.
I'd ask the court to enter a default judgment, please.
Is there anyone here to object to default judgment? Default judgment is granted. Defendants fail to appear. Default judgment is granted. Defendant must vacate by May 22nd, or writ may issue. And the Aldridges, I was optimistic on getting this stuff done before lunch, but have you sent credit exchange documentation?
I didn't hear that, Your Honor.
Does Ms. Lewan have what you all have, and do you all have what Ms. Lewan has?
We had spoken at the last hearing. They did send me a copy of the deed. I did obtain a copy of the court file. And at our last hearing, you told me that we should come today to present our research on the issue of whether or not this was the proper case in this matter and why.
Okay. Yeah.
Was correct or incorrect.
So realistically, yeah, we'll do it right after lunch, but you all will be the first case called. You all been waiting. I apologize. I thought I could do it before, but I can't. So.
Okay, so.
We're gonna get it started on the lunch and go for it, and we can come back at at 1:40. I'll hear the arguments.
Say 140, Your Honor.
Yeah, 1:40.
And Ms. Smith, do you hear that? We're gonna call the case at 1:40.
Yes, ma'am.
So just call back to the Zoom at 1:30.
Okay, yes, ma'am.
Thank you.
Thank you. Thank you, Your Honor.
You're welcome. So we finished 6470, counsel, correct? Mr. Horka, we finished 6470.
We did, that was the default.
And you have 6407 still?
Yeah, because we didn't put that on the record, Judge.
Yep, ready on that one?
Okay, calling case number 23346-407. This is Go-To Guide Property Management versus Ariel Smith and all occupants.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff.
Ariel Smith here.
Your Honor, I believe that this is Mr. Barishai's case.
You know,
No,
actually,
I'm sorry, Mr. Horka. Yes.
Yeah, no problem, Ms. Carey. I ended up working out with Ms. Smith a proposed consent judgment for a June 9th move out date. If she's not here, I'm happy to do as a default with that same date.
Okay. Sure, it doesn't appear that she is here right now. So please proceed. I'm ready for you.
And then attorneys, I'm sorry, Your Honor, at this point, I'd ask for a default judgment. June 9th is the vacate date on that.
Default judgment, defendant must vacate by June 9th, 2023, or writ may issue. Default judgment is entered. Defendant was previously here. Parties were able to negotiate, and this judgment is being entered as a default, consistent with the terms negotiated by parties. So although it's a default, this is quasi default. Okay, that takes care of 407.
And 075, we have a proposed resolution as well.
075, this is Jasmine Jones. On case number 23346-075, 532 Tidal Way LLC versus Jasmine Jones and all occupants.
Good afternoon, Joe Horka, P75969, on behalf of 532.
Good afternoon, Your Honor. Robert Santiago, Michigan Legal Services, P57157, on behalf of the tenant Jasmine Jones, who is present in the courtroom. Jasmine, would you please state your name for the record?
Yes, good morning. My name is Jasmine Jones.
Hello, Ms. Jones. Good morning. Good afternoon.
Yeah, good afternoon.
All right. Okay, I'm ready for you all.
Your parties would like to submit a consent order for conditional dismissal, box 4B checked, June 19th as the payer move date. The total due as of today with rent and court costs is $3,254.69.
That is correct, Judge. And just to make the court aware, that includes $158 of court fees.
Okay, and
Let's write that out.
okay, and is this in the form of a consent judgment or
Conditional dismissal, Judge.
Okay, I missed that. And it's 4B check?
Yes.
All right, and Ms. Jones, do you give permission to Mr. Santiago to sign your name?
I do.
All right. Court is
And I'm sorry,
adjourned.
you said how much is in court fees?
It was $158.
Okay.
And what's the total amount? One more time.
The total amount was $3,254.69, Judge.
All right, to be paid by
June 19th.
June 19th. Right, it's lunchtime. Okay, all right, Ms. Jones. Good luck. If you make the payment or vacate, your case will be dismissed. If not, a judgment and a writ of eviction can enter simultaneously.
Okay.
All right, good luck.
Good luck,
Thank you.
Jasmine. Take care.
Have a good one.
Thanks, Judge. Thanks, Joe.
All right. Mr. Hart, is Kyle Miller here? Calling case
With
number.
Attorney Fisher.
Okay. All right, we're gonna take a lunch break. We'll be back. We have a few cases left on the morning docket. Ms. Orangelo, Mac Faulkner. I didn't get to you all in time. Attorney Fawaz? Attorney Fawaz, Tyree Rump and Tressa Copeland. I'll see you all back at 1:45. And I'll see Ms. Davis.
Yes, Your Honor.
Can we do one more?
Sure.
Let's get Ms. King out of here.
Okay.
Calling case number 2334-6121. This is Orangelo Mac Faulkner versus Malone, Trisha Malone King. And all,
Yes, sir.
can you please state your name for the record? And parties?
Hi,
Who are-
I'm
Hello.
Angelo Mac Faulkner.
Thank you.
You're welcome.
And Ms. King, can you state your name for the record?
Sure, Trisha Malone King.
All right, thank you. And Ms. Mac Faulkner, are you the owner of the property at 19314 Ardmore?
Yes, I am, sir.
All right, thank you.
You're
And
welcome.
Ms. King, do you reside at that address, 19314?
Yes, I currently do, but guess what? I'm being out of league. They just sent me a an approval on closing on the house. So I'm excited. I'm not trying to take this energy with me today. So yes, I reside here currently.
Okay.
I'm too excited.
All right. So this is a complaint to recover possession of property. How much time do you need?
Since buying 30 days would be awesome, but I don't know if she would agree to that.
I will agree to that, Ms. King, without a problem.
Awesome. Thank you. I'm too excited. I'm trying not to take this energy with me, y'all. So
I'm so glad. I'm really glad for you.
All right, well, it sounds like we have a solution. Is there any objection to an all occupants judgment?
I would appreciate that. Thank you for offering.
I'm putting it on the table, but I'm impartial. So if you say no, it's okay. I'm just throwing it on the table. You all are both unrepresented. If it's a no, if it's a yes, it doesn't make a difference to me. So
Ms. Mack, do you agree?
Yes.
Thank you.
You're welcome.
all right, let's stick positive energy. All right,
Yes, all day. I really
Judge,
appreciate y'all.
a judgment by hearing where parties will, for all occupants, we're gonna remove your name as a named party, but all occupants, everyone, regardless of who you are, must vacate by is it June 12th? That's the first business day after 30 days. So June 12th, that's a Monday. June 12th, 2023, all occupants must be vacated or a writ of eviction can issue after that date.
Awesome. I appreciate you.
Yes.
I appreciate all of you all. So
All right.
you all have a good day. Ms. Mac Faulkner, I still need a
Yes.
judgment from you. Send it in.
Yeah, I'm sorry, I didn't hear you, sir.
I need a judgment from you.
Okay, all right, no problem. Yes.
So send that in to me and good luck.
Thank
Okay.
you.
All right. Thank you so much, sir. Thank you.
You guys have a good day.
All right. Thank
All
you.
right.
Thank you.
Positive note. All right, take care. All right, we'll be back at 1:40. Ms. Davis, did we get your case sorted? Let's see. Our party's ready on your case? I'll call it. Is Sade Reed ready?
No, Your Honor, she's waiting to speak to an attorney.
All right, Ms. Davis, I'll see you after lunch.
Okay, have a good lunch.
Your Honor, will you leave the Zoom room open so that we can meet with folks?
Absolutely.
Thank you.
Your Honor, hey, can you hear me? Sorry, Your Honor, my thing had some technical difficulties. Are you able to hear me, Your Honor?
Yeah, I can hear you now. I can hear you.
Okay, how you doing this morning?
Afternoon, I'm hungry. I'm hungry.
Okay, Mr. Sabree, the girl Sade that's coming into the thing today, she hasn't been present the past 2 court dates, sir. I've been to court on this twice. I was supposed to receive a judgment the last time that I came. I didn't make the last court date, but I had 2 prior to that I attended. They told me, Miss Davis, you will receive your judgment because Sade Reed was not present, sir. Also, this is a squatter inside my property. There is no lease present. She's been threatening to vandalize my property. I wasn't able to attend the last hearing because I had a kidney surgery.
Ms. Davis, we're about to go to lunch. The person, Sade Reed, I would have called your case earlier. Ms. Reed is still talking to an attorney. So I can't call the case until both sides are here. So until the attorney is ready, I can't call your case because I'm just gonna have to recall it. So I appreciate all of the information that you just gave me. This will be again in about an hour. So
Okay, I need you to help me out with this because I'm getting done bad here, Mr. Sabree. And I just got out of a kidney surgery.
I need you to help me out and hold off on your argument until 1:45. And
Okay,
then
thank you. Enjoy your lunch.
likewise, thank you.
Okay.
All right, I'll leave the Zoom room open.
Thank you.
Ms. Smith, I just sent you an invitation to room 6. If you could accept that, that would be great.
Okay, thank you. My pleasure. Hopefully the judge will call us in 15 minutes.
Hi, is the clerk there?
Hello, the person with the phone number ending 4719, can you hear me?
Yes,
Hi, what's your name?
Brian Adams.
Okay, and you have a case this afternoon with Judge Sabree, right, at 1:30?
Yes.
Okay, great. I'm going to go ahead and get you renamed. The court is still on their lunch break. They will be for about another 10 minutes, but so we all just have to sit tight and wait till they're back.
Okay.
Hello, the phone number ending in 8138. Can you hear me? You may have to press *6 on your phone if you're muted. There you go.
I got it. Yeah.
Okay, what's your name?
Angela Edwards and Andre Edwards.
Okay, and you have a case this afternoon in Judge Sabree's courtroom?
Yes.
Do you know the case number?
Yes. 233 461 72.
Hello?
Yes, one second, Mr. Barnard.
Okay.
Okay. All right, Mr. Edwards, I'll go ahead and get you renamed. The court is still on their lunch break, so they won't be back for another 10 minutes or so.
Sure.
So we're all just hanging out until they get back. Okay, Mr. Barnard, are you here for case ending in 6220?
Yes, I am.
Okay. All right, I'm just gonna put that on your name, and we're, like I said, just waiting for the judge and his staff to get back from lunch break.
You can't see me, can you? Because I can't
No.
see.
Nope, we cannot see you.
Am I going to be able to see you? Are you going to be able to see me?
Yeah, when the judge comes back, you'll be able to see more. I don't think anyone really has cameras turned on right now.
Okay, okay. I was just making sure I didn't do anything wrong.
Nope, nope. The phone number ending in 1031, can you hear me?
Yes. Can you hear me?
Yes, what is your name?
Corey Mundy, MUNDY.
Great, okay. I'll go ahead and get you renamed. The court is, the judge and his staff are still at lunch break. They'll be back in about 10 minutes. So we're just getting people checked in and renamed. So there's nothing to do right now while we wait for them to come back.
Okay. You don't want me to call you back?
That's up to you. The court will, the judge will be back in about 5 or 10 minutes.
Yeah, just stay on, Mr. Monday.
Oh, hi, Miss Davis.
Hey, I just came on. I said I'd come on early too and help rename everybody. Yeah. Yeah. So just stay on and the judge will be out shortly. Don't leave.
All right.
Press *6 on your device, and when you hear the court or your attorney call your name, press *6 again.
Gotcha. Okay.
Thanks.
Okay, Miss Davis, I'll stop now. I was just trying to get a head start for you.
Miss Nokia, unmute your device. You with the burgundy shirt on, or is that a sir? I don't know. I can't see. Unmute your device. The person just signed in iPhone. What's your name for court?
Lene Cheatham.
Okay, give me a second. I'm gonna rename you. And your letter is at 1:30?
Yes.
1 second. I thought I saw that on here. Well, Judge Adam Sabree?
That's what it say on this computer thing, but on my paper it said
What's the-
Shine. Huh?
Okay, I think you're in the wrong courtroom. What's the last 3 digits of your case number? Because I don't see you on here.
The last 3 digits is
And you said it's Cheatham?
yes.
What's the last 3 digits of your case number?
I think it's 998.
Let me see if I see that.
Okay.
And for 1:30, nope, I don't see that. So it's a possibility you with Judge Jacquet. So let me give you a number to dial in for Judge Jacquet.
Okay.
And then if it's a problem, you can always come back.
Okay.
But I don't see you on Judge Adam
Okay.
Sabree's courtroom. So it's 360
360
538
538
0000.
000. Okay.
Okay.
Thank you.
Leave this meeting and go over there.
Okay.
All right, thanks.
Yeah.
Miss Nokia.
Oh.
The person signed in under Nokia. The person just signed in under 1+. What's your name for court?
Alicia Smith.
You have a matter with Judge Adam Sabree today?
Yes, ma'am.
Okay, yep, you're in the right courtroom. Let me rename you and the court will be with you shortly.
Okay, thank you.
You can place your device on mute, Miss Smith,
Yes, ma'am.
and I'll rename you. Give me a second. Who else I saw? iPhone. There's a person signed in under iPhone. What's your name for court? iPhone. The person just signed in under iPhone.
Is that me?
No, hey, Miss Davis. No, that's not you. We have you checked in already.
Okay.
Okay. All righty. You're just waiting for the judge. There's a person signed in under iPhone. The person signed under iPhone. The person signed under iPhone. What's your name for court?
Can you hear me?
Yes. What's your name for court? You have
Sade
iPhone.
Reed. I didn't hear the audio at first. Sade Reed.
Okay, and you here with Judge Sabree at 1:30?
We was coming back from they was coming back from a lunch break.
Okay, yep, you were at 10:31. Yep. Let me rename you. And the court will be with you shortly. There's a person signed in under Samsung. What's your name for court? Samsung, the young lady with the blonde hair. What's your name for court?
Are you
Yep,
talking?
yep, I am.
Keisha Howell.
Okay, good afternoon, Ms. Howell.
Good afternoon.
What's the last 3 digits of your case number?
72. Well, no, it's 25259.
What's the judge on your paperwork?
Hold on. Sean K.
Yeah, you're in the wrong courtroom. Let me give you another meeting ID to log on to.
Hold on 1 second. Like, put it in seven. Oh. Okay, what's the number?
It's 360-538-0000.
Okay, so 360-538-0000.
Yes, so leave this meeting and go over to Judge Jacquet.
Okay, thank you.
You're welcome.
Madam Court Reporter.
Good morning.
Hi, are you able to give co-host?
No, the judge is here now. He'll give you co-host. What's your name? Christine?
Christina, yes.
Okay.
Right
All
here.
right.
Thank you.
Okay. Main thing I need to know is, are you going on the ceiling or on the floor?
We arranged for a meeting and it was in February. Oops.
There's a person signed in on the phone number in it and 0800. What's your name for court?
Ryan Reed,
And what time is your matter today with Judge Adam Sabree?
1:30.
William Reed?
Ryan Reed, RYAN.
What's the last 3 digits of your case number?
I actually don't have it in front of me.
I don't see you on this docket this afternoon with Judge Adam Sabree. Can you get your paperwork? You might
I'm
be in
nowhere
the
near it.
courtroom.
Yeah, I just dialed the number that was on the back of the paper.
Okay, you might be in the wrong courtroom. Are you still? Oh, I thought you left. I don't live in here. Going to the next one. No, we ain't got you. Okay. Good afternoon. The person signed in under Galaxy S9, the young man with the glasses on. What's your name for court? Unmute your device. Unmute your device, sir.
Hello?
I have you, Mr. Adams.
Yes,
We have you checked in.
okay.
Okay, Lomax Boyd.
What is your name, sir?
Lomax Boyd, B-O-Y-D.
Okay, you are in the correct courtroom. The court will be with you shortly. Let me rename
Okay.
you.
Okay,
You can mute your device.
all right.
The person signed in under Nokia 3V. The young lady with the black shirt on. What's your name for court? Mr. Bornkamp. Joel
Yes.
Bornkamp.
Yes, I'm sorry. So I'm here on behalf of U.S. Bank Trust National Association, taking the place of former counsel Ethan Hill in this matter.
What's the last 3 digits of your case number, sir?
6220 or 220, I'm sorry.
220. And what, okay, yep. Let's see you on here. And tell me your name again.
Sure. My name's Joel Bornkamp. I'm taking the place of Ethan Hill, who's no longer with our law firm. I can enter an appearance if the court would like afterwards, but I am filling in for him today.
Okay, spell your first and last name for me and give me your P number.
My first name is Joel, Joel. My last name is Bornkamp, Bornkamp. And my P number is P85016.
85, one more time,
016.
Okay. All right, thanks. You can place your device on mute. The court will be with you shortly.
Thank you very much.
You're welcome.
And good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
We have about 10 cases this afternoon and a handful of cases this morning that just needed a little bit more time to get sorted.
Yeah.
And negotiated. So if parties have anything ready, any defaults, any dismissals, please put a hand up in the chat like Mr. Horka, and I will try my best to get you out of here. Mr. Horka.
Judge, can you recall a case ending in 407 from the morning?
407, what time?
It was at 10 a.m.
Oh, thank
Ariel Smith, who came in late. Recalling case number 23346-407, Go-To Guy Property Management versus Ariel Smith.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. Ariel Smith.
I'm here. Good morning. Good afternoon.
Good afternoon. This matter was defaulted. Previous default judgment was entered in the morning. Should this change, Mr. Horka?
Aaron, this is the one that I had worked out a proposed consent in a breakout room with a June 9th vacate date. And when she didn't respond to the court call, I changed it to a default. Just need this changed back to a consent, please.
Okay. This matter is, the default judgment is set aside and the court will enter a consent judgment consistent with the same terms of the default judgment. Ms. Smith, are you represented by counsel?
I spoke to Joe, but other than that, no.
Your Honor, I gave her a bit of advice during the lunch break, just to let her know what was going on when she came back.
Okay. MCR 4.201I states that if you disagree with what you've entered into today, you have 3 days to file a motion to set it aside. We're not in person, so does Mr. Horka have permission to sign your name on this consent judgment?
Yes.
All right, the court is satisfied. This concludes this matter. You are free to go, Ms. Smith.
Thank you. Have a great afternoon.
All right, you too.
Judge, I'll submit that under an all occupants judgment.
Okay, all right.
Thanks. I have one last one from the morning ending in 116, if you're ready.
Calling case number 233461116. It's the DG Residential Sales versus Kyle Miller and all occupants.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Good afternoon, Your Honor. Janetta Fisher with Michigan Legal Services, P72872, representing Kelly Miller. I think she may still be in a breakout room, and I don't have any privilege to get to the breakout room.
I just brought her back, Miss Fisher. She should be in the main session now.
Okay, thank you.
Kyle Miller, can you state your name for the record?
I like Kelly Miller.
Kelly Miller. Good morning. Good afternoon, Ms. Miller.
The parties have spoken. We'd like to submit a conditional dismissal with box 4B checked as follows. There's a total with rent and court costs of $4,890. My understanding that Ms. Miller will pay $500 of that on or before June 1st. Provided she does that, her move-out date would be extended to June 26th. Either pay the balance or vacate from the property.
I thought that it was 4,690.
That's what I thought too, and that's what I told her. I believe that included the court costs. Oh, okay. Yeah, it's 4,690.
I believe that's right. I think I hand scribbled incorrect amounts. Yes, 4,690. 4,690.
All right, so we're gonna enter a conditional dismissal for $4,690. $500 to be paid June 1st. And if that's paid, defendant plans to vacate by June 6th, is that correct?
No,
26, Your Honor.
26.
Okay, all right, that sounds about right. Okay, all right, I'm satisfied. Does, Ms. Miller, do you give Ms. Fisher consent to sign your name?
Yes.
Okay, court is satisfied. Have a great day, Ms. Miller.
Thank you, Your Honor.
Well,
thank you.
Thank you, Mr. Horka. Right. Let's get parties. Following case number, okay, Mr. Juan, you have something?
We're still waiting on the 10 o'clock, 4390.
I'm ready to call it. Let's see.
I'm here, Miss Suzanne.
I see you, April. Thank you.
4-3, recalling case number, oh, it's not a recall. Calling case number 233-44390, Emery Aldridge versus April Smith.
Present.
Suzanne Stepich Lawan, P48702, Michigan Legal Services, on behalf of the defendant, April Smith, who is in the courtroom with us. Ms. Smith, will you please state your name for the record?
April Zena Smith and Jerry Daniel Aldridge.
I was going to say also with Ms. Smith is her husband / partner. I'm not quite sure what to call them. Jerry Aldridge.
That's not our husband, Judge. They're not legally married.
All right, her partner. All right. Okay, the parties worked out a resolution?
No, Your Honor, you asked us to come back. You said you needed some research done on the issues at hand. This is and if you'd like me to speak, I can go ahead, or if.
Okay, so there's a, okay, all right. And I understand why you're saying that now, Mr. Aldridge. All right, so April Smith is an occupant
Yes, sir.
in a property.
And Your Honor, I would argue with that a bit. If I've done some research and prepared a document that I can send you if you should desire.
All right, I'm just recapping is, she's an occupant in a property where there's a joint tenancy amongst 5 brothers, is that correct?
I believe it's 4 brothers and a sister,
That's correct.
and they're joint tenants with full rights of survivorship.
All right. So I'll let you all present your cases, whoever wants to go first, Mr. Aldridge, Ms. Juan.
Well, as we spoke at the last hearing, Your Honor, April Smith, let me back up. Last year, our mother health began to decline. Consequently, my brother and I, along with other family members, offered assistance that mostly involved monitoring her walking to the bathroom, since she had a couple of experiences where she had fallen and sustained some injuries. To ensure our mother was monitored during the times we could not be available, under these conditions, we would monitor our mother. We allowed her to stay, April to stay in our home at no cost. After our mother passed, we asked her to leave because her service was no longer needed, and other members of our family expressed interest in possibly moving in our home. So we issued a notice to quit, and she agreed to move out within 30 days. When the process, we then proceeded with the eviction note process, and she continued to advise that she would move, that she had located a new home and then changed her mailing address, yet she still has not moved. We are therefore requesting the court assistance in having her vacated from the home. Once again, she was just there to help us and assist us in taking care of our mother. And that was the only reason. And now that our mother has passed. So our mother has passed, and we agreed, as well as April Smith agreed, that she would move out and find some other means of living.
Okay. All right, thank you, Mr. Aldridge. Ms. Lamont.
Your
You know
Honor,
what, Your Honor, that's not true.
Mr.
Because
Aldridge,
you know what?
Mr. Aldridge or Ms. Smith, let me talk. So this is a case where 5 siblings hold the property as joint tenants with rights of survivorship. That entitles each of the siblings to possession of the property. There's no limit or no restrictions as to who the owner may associate with on the property, or who they may have visit them, as long as they are not preventing the other owners from possession of the property. There have been no allegations that either April Smith, my client, nor Jerry Aldridge, whom she has lived with as husband and wife, even though they're not legally married, for 38 years. They share a 38.
What is husband and his wife if they're not husband and wife?
I realize that, Your Honor, but I'm just establishing that they asked the brother, who is a legal owner of the property, as well as the woman he has been living with for 33 years, to move in. Correct? The Albro v. Allen 434 MISH 271 sets forth that joint tenants with rights of survivorship each hold concurrent life estates with contingent remainders and can in fact convey their life interest in the property. So if Mr. Jerry Aldridge chooses to share his possession with the woman he's been living with 38 years, he could lease it to her if he so wished, but instead he has had her living with him as his partner for the last 2 years. Albro v. Allen went on to say that while the principles of concurrent ownership have never guaranteed amiability between contestant or co-tenants in both an ordinary joint tenancy and a tenancy in common, an original co-tenant might find himself sharing possession as a tenant in common with a stranger after conveyance by a former co-tenant. And the remedy of partition is available if the co-tenants cannot get along. Trying to evict Ms. Smith, who's not claiming any possessory interest in this property. She is living there with her partner as his partner. They're not preventing possession by any of the other 4 siblings. And in fact, this has been a retaliatory nature that once the mother Aldridge passed, a notice to quit was served. Utilities were cut off. Threats have been made. They're having mail returned. Miss Smith has not changed her mail, but some pieces of mail, including applications for other housing, have been returned to sender. In addition, I mean, the family ties are so strong that the plaintiff in this case and Ms. Smith share a grandson. And because Ms. Smith has a 44-year-old son from a previous relationship who shares a child with the plaintiff's granddaughter or daughter. So they have a grandchild together. This woman has been accepted as family for 38 years, and now they're just trying to evict one of the members, not their co-tenant, but there's no reason why he can't have whoever he wants in that home with him, as long as she's not presenting the possessory interest. I would argue, as I argued in the first hearing, that the correct action for this would be for a petition to petition the circuit court to partition this property. And Mr. Jerry Aldridge and Ms. Smith have wanted to keep the family membership intact. This has been a family home. They hold it dear, and they would like nothing better than to figure out a resolution with Mr. Aldridge's brothers, who have refused to speak to them since they filed the notice to quit. So I suggested we file for a partition, and they said, see what happens today. But if they can't stay in the property, then they are going to file to have the house sold and the money divided between the siblings. I have more citations if you would like.
Okay, what was that Algo v. Allen site?
Algo v. Allen, 434 Mish 271, 1990. It has a slightly different fact situation. It basically says that joint tenants with rights of survivorship hold their concurrent life estates, but they can convey those life estates. And if they can convey those life estates, I would further that to say they then can live with whoever they want, as long as they are not interfering with the other possessory interests in the property.
It says that they can convey their joint tenancy life estates.
They can convey their life estate. They could rent out. That's what it says. It says, this is a quote, the principle that life estates are transferable, together with the rule that an expectant estate may not be defeated by alienation of a precedent estate, leads us to conclude that a person sharing a joint life estate with a dual contingent remainders may convey interest in the joint life estate without destroying the co-tenant's contingent remainder. So if Mr. Jerry Aldridge wishes to lease out his 1/5 of the home to someone, to a total stranger, he could do that. He does not destroy the survivorship rights, but he could convey his life interest.
So long as he has an interest.
And he does have an interest. He is listed on the deed, Your Honor.
Your Honor, may can I
go ahead.
Can I appeal to the court? My brother Frank is here. He'd like to speak to the court if that's okay.
All right, Mr. Aldridge, can you state your name for the record?
Frank Aldridge. As my brother iterated earlier, the condition under which she was allowed to stay there was solely contingent on being able to provide assistance to our mother, who has since passed. And that was the only reason why she was allowed to stay there at no cost, regardless of what my other brother felt, Jerry, that had nothing to do, and they were all in agreement with that. They were all in agreement with it. That was the understanding. So when our mother passed, that condition no longer existed for her to be. We have other plans for that property. We have other relatives. I have a daughter right now with a very debilitating illness. I don't want to get too graphic, and may have to stay there because she's going to need some assistance. And so we're thinking through all of this in terms of who's going to occupy that house, who was purchased by our grandmother years and years ago, of passed and left it to our mother. And so my mother agreed for her to be there only under the conditions that she offered the assistance that Emery and I had outlined. And now that that condition no longer exists, and also because they had said earlier that they would voluntarily leave and continue to not do that, we've made certain that we still we're paying the utilities, we pay the insurance, we're doing all these things, So I would move for the court to just rule in our favor because we don't want it there. And there's some other things there, stealing and things like that. But I don't really want that to factor into it. The thing is, we followed the process. We provided, feedback, a notice to quit. She agreed. She identified property, gave us addresses, things of that nature, saying that she would move and then continue not to do it. And has also told people in the neighborhood who we know how she was going to go about trying to keep that property. So that's not something that we find acceptable. We just hope that the court take that into
She can't listen.
And
Can't obtain the property. One, how many bedrooms are in this house?
1, 2, 3, 4.
So somebody is losing automatically. If all 5 parties were to access and enjoy and try to get their quiet use and enjoyment out of the property, practically speaking, it's possible, but you all will be probably on top of each other as 5 adults, probably with families, as you stated. So are you all right? So it seems like the issue is really you're footing the bill for your brother and his girlfriend to stay at the house. I'm not.
Your Honor, I would disagree with that because Ms. Smith and Mr. Jerry Aldridge, first of all, Mr. Jerry Aldridge wants Ms. Smith to stay, and in fact said on the record in a prior hearing that he objected to this eviction proceeding. In addition, they were paying their mother an amount of money for utilities every month, and until the notice to quit was filed, continued to pay the brothers a money for utilities. Once they filed the notice to quit,
That's true. That's not true, Your Honor. That's
utilities
not
were cut off, and they are now in Ms. Smith's name because she had to put them in her name so they had electricity and heat.
How did Ms. Smith put the utilities in her name?
Or with Mr. Jerry Aldridge, I'm not sure. But they did it together so that they could maintain electricity and heat.
All right, all right. Does everyone, do all 4 brothers and sister have access to the property?
According to my client, they have not prevented anyone from having access to the property.
Okay, Mr. Emery Aldridge, the Aldridge brothers who are together. Can you stick a key in the door and walk into that property? You're muted. You all are both muted. All right, here you go.
Okay. Yes, we do have keys, and from time to time we've gone over there to pick up mail that's to my mother.
Can you walk in and make breakfast?
We can do anything we want.
Yes, Your Honor.
We got complete access.
Okay.
In fact, some of our grandchildren have access because they too were looking in on our mother.
All right. I don't see practically how you can evict someone who has access to the home, has rightful access to the home through your brother. Your brother has access, so that's his, if he's sleeping in the bed, then she can sleep in the bed with them without disturbing your ability to utilize the house. So unless, if you would have told me they took over the entire house, then that's an issue. And I would suggest getting the house partitioned, but I can't remove, I could file an eviction against her, but she can walk in the exact next day and you won't have a claim against her. I mean, maybe she shouldn't be getting her mail there, but
she was never given a key. She was never given a key. Only my brother had a key to the house.
I think that's something you all, I guess, could vote on. But if she's a guest of your brother, how do we stop that? How do you stop that? How do you stop that? I don't.
We also know that, first of all, my brother doesn't have any visible means of support. We've been supporting him. Doesn't have any employment, doesn't have any income whatsoever. He's been in these situations before because of other problems. You know, I don't want to get into all of his background, but he hasn't had employment for quite some time. Doesn't have a means to pay any of the bills to begin with. And she receives some form of assistance. But as far as them paying any utilities to my mother's money, that wasn't happening. That wasn't, in fact, my mother did not desire for them to even be there. And we said, well, given these conditions, we can't be here 24/7 all the time, and we have other things that we're doing. He and she could help. And that was the agreement. And then when that ended, and we brought that to their attention, and what our desire was, our brother Jerry was in agreement with that. He has since changed his mind, but they both had agreed to move out. They were going to get a place of their own. That was always their plan. In fact, while my mother was living, they were going down that path.
And Your Honor, I would say what Mr. Jerry Aldridge does is irrelevant. And if his partner or girlfriend chooses to assist him with what income she has, again, it's irrelevant. He has right to the property, as much right as both of the gentlemen who are speaking against him. And if he chooses to share his portion of the property with his girlfriend, it's no different than if one of these gentlemen had a friend that they wish to share their portion of the property with. They all have equal rights.
Your Honor, what's relevant is that we had an agreement initially that April Smith would assist us in taking care of our mother. That was the agreement. And
so long as she did that, she could stay. But they don't even have the visible means to even maintain the home, pay taxes. They don't have that. And so why would they be trusted with something like that when they can't even maintain the home?
Because
and Your Honor, according to Mr. Jerry Smith, they have been solely responsible for snow removal, lawn care, landscaping, all of that for the past 2 years.
No, that's not true. That's not true.
That's not true.
Our sister paid for that and my mother paid for the landscaping. They're not telling you the truth.
They basically stayed there for free. And the only reason, again, the relevancy of what's going on is that initially, April and my brother Jerry was there to assist us in taking care of our mother, who was ill at the time. Now she's passed, and the assistance we don't need it anymore. We don't need it.
Your Honor, I would argue that the appropriate action would be to dismiss this eviction action and allow us to file a partition action in the circuit court. And that way they don't have to worry about whether or not their brother, who owns an equal amount of interest in this property, has a means of income or not, because the income will be divided, the home will be sold, and they'll each get their monetary portion.
And I would like to make an appeal that the family members have a vote on that as a group.
Well, family members, yeah, this is, as it relates to landlord tenant, because this is really, yeah, this, you all are gonna have issues if your testimony, if I'm taking your testimony as truthful, which I am, that means that you're all gonna have issues if you're paying the bills for this property and expenses that you're not enjoying. So you're gonna protect your interests, you're gonna continue to pay, but you have to ensure your ability to enjoy the property. You can't evict Ms. Smith without partitioning the house because your brother is gonna allow her to be in there. He has a lawful right. So unless they're denying you your full access or enjoyment of the property or costing you something that's outside of his 20% obligation or your 20% obligation, that's an argument. But as it relates to landlord tenant court, I think it's, I'm going to dismiss this matter for this reasoning. If I enter a judgment, it's going to be problematic and it won't have any effect because your brother owns the house along with you all, and he can open the door and allow her to come right back in, and we'll be right back where we were. So I don't have a solution for this. I don't have a solution for this. Circuit court partition may be your best solution, or some type of agreement amongst all 5 parties, but there was an oral agreement for her to vacate, but she clearly breached that, and the court's not going to evict her. Actually,
Your Honor, if you find that if you're going to make a judgment based on only one side's testimony, I would ask that we take testimony of my clients as well, because
I had to be quiet.
they believe.
You
Well,
told your client.
because I didn't realize we were taking testimony, and I thought that an argument over yelling over you was disrespectful.
That's
So
fair.
if you would like to hear testimony, we can take testimony on this. But I can tell you that Jerry Aldridge is going to say that he and April have been living there and they had no agreement to leave.
They don't have to leave. He doesn't have to leave, but
I realize I was.
Yeah.
Do you understand what I'm saying?
They're gonna come back, and he has a legal, you can't deny her ability to stay there as a guest of your brother. That's the real issue. So I'm gonna dismiss this matter. I'm gonna dismiss this without prejudice. That doesn't prevent you from refiling it. Doesn't prevent you from appealing this. But right now, I'm going to dismiss this matter because I don't see how this eviction would even be executed. So that's the final ruling. Wasn't an easy decision, but I'm going to dismiss this matter, and I suggest you all get some legal assistance to help navigate through this endeavor.
Thank you, Your Honor. Ms. Smith, I'm going to pull you into a breakout room.
All right, that concludes this matter. Yeah, fine. Yeah. All right, well, thank you. All right, our party's ready on, I know you're ready on case number 23346-415, Michelle Jones versus Anthony Adams.
Defense is ready, Your Honor.
Good afternoon, Your Honor. Once again, Ali Dagger appearing on behalf of the estate. Michelle Jones, personal representative of the estate of Jim Hodo, Your Honor.
Thank you.
And good afternoon, Your Honor. Tom Barishai, P83642 on behalf of the defendants, the Adamses.
All right, thank you. And we held this over until lunch because we had a few outstanding issues that need to be addressed. All right. First and foremost, is Michelle Jones, is it contested that Michelle Jones is the executor or the administrator of the estate?
No, Your Honor. We were presented the evidence that she is the personal representative of the estate.
Okay, so personal representative, thank you. All right. So what issues are at contention right now?
Your Honor, it was mainly sort of I had concerns because I didn't have the file in front of me and because the ROA is down, so the case lookup that I used did not mention the estate itself. And so if the matter was being brought on behalf of the estate, I thought the estate should be named. Attorney Dagger has stated, I believe, that the estate is named as a plaintiff.
That is correct, Your Honor. The estate is the plaintiff in this matter. And at this point, Judge, we're asking for possession under the 10-day rule.
Your Honor, assuming everything is true and the court determines that Michelle Jones or the estate, whoever in this case, is the proper plaintiff, my client's request two things for the court to consider. First, that if a judgment's to enter, it enter against all occupants rather than in their name. They are basically in the house because they were taking care of the decedent in his old age, and it would be a shame for them to be evicted or for an eviction to enter in their record because of that. And second, they would request that the court grant them as much time as the court is willing to. 10 days is quite brief, and they, until today, they were unsure whether Miss Jones was in fact the personal representative because they were contesting that, I believe, in the probate matter.
May I address that, Your Honor?
Sure.
The Miss Adamson or Mr. Adamson or his wife have attended every single probate hearing. We're fully aware and made that argument in front of the probate court, which was rejected. The probate hearing has been going on since the beginning of the year. They were fully aware because we made it perfectly clear at every probate hearing that it's our intention that they be moved out and the house be sold and disposed of according to the probate statute. They had plenty, ample notice of the need to vacate the property. Our major concern, however, is that it's very possible that they're in fact beginning to destroy the home from the inside. We suspect that that's happening. At this point in time, Your Honor, I would ask the court give the 10 days for the statute.
Your Honor, if I could respond to that briefly, I don't believe Attorney Dagger has provided any evidence that there is destruction of the home or anything of the sort. So we would request that that not be considered.
Hey, my client is the personal representative, has attempted for several weeks now after the appointment for her to enter the home. They have basically put a dog on the scene, preventing anyone from approaching anything, even to observe the backyard or otherwise. We've attempted on a number of occasions to inspect the house, and we have not been able to provide. Now, the damage that we can observe had been observed through by standing at the porch and see what's happening on the inside. At this point in time, Your Honor, time is at the essence that we claim and we begin her obligation under the law as a fiduciary to maintain the house and not to commit waste. And any time provided in addition to 10 days is in fact the commission of waste.
Your Honor, I'd object to the idea that extending some time for the occupants to find new housing is waste, unless Attorney Dagger has, a purchase agreement with another party, maybe, or something along those lines.
Let's talk
As the council is well aware, purchase agreement cannot be signed without anyone looking and inspecting the house. So yes, time is a waste in this case in lots of different dimensions, sir.
Sorry, counsel, I have to object to that as well. It is very possible to sell a property without someone being in there. People buy properties from across the country and across the continents.
And that's the very definition of waste, in that my client will not be able to maximize the purchase price by allowing people inside the home. Tom, we can go back and forth on this, but I think, Your Honor, at this point, we would like the court to move forward with their decision.
Of course, before though, I'd just like to object to your definition of waste. I think other parties have different definitions, but we'll leave it to the court.
I'm speaking strictly of the legal definition of waste. If you'd like me to cite the cases for you, I will do that at some point outside the purview.
Ms. Adams, Ms. Adams, is it Mr. Adams?
Mr. Adams.
Mr. Adams, have you allowed parties to inspect the property?
No one has came to this house since this matter has been in court. All right, we are not destroying this house. I would not do that to my grandparents. I have taken care of this house since I have taken care of my mother, my father, and my grandfather.
All right.
So I would not disrespect them in no kind of way as far as this household. I have paid the taxes on this house since my mother.
I just asked were parties, thank you. I just wanted to get that small bit of information.
Yeah,
the court
came to this house.
All right. Okay, the court's gonna enter a judgment by hearing. Whereas, is there any objection to an all occupants judgment, counsel?
No, you're right. There is.
Court is gonna enter an all occupants judgment where parties must vacate by May 31st, or writ may issue. And parties must allow an inspection within 14 days.
I'll submit the order, Your Honor. Judge, this is my first hearing with you. How do you normally want us to submit an order to you?
By fax is probably, you can do it by fax or by fax is most effective, because if not, it may get lost.
Attorney Dagger, I do this pretty regularly. If you'd like, I can send you a copy and then prepare it and we can get it over to court.
I appreciate that. Thank you.
Okay.
All right, good luck to all parties.
Thank you, Your Honor.
Have a great day.
You too, Judge. Thank you very much.
Your
Honor.
We'll speak in a breakout room. Hang on. Your Honor, could you make me a co-host? Thank you.
Excuse me, Your Honor. I don't mean to interrupt, but my name hasn't gotten called yet, and I'm just wondering what's going on. I've been in the call for like 6:10 this morning. My name is William Thompson.
You know what's going on? Okay. Stephen Carter here. Is Stephen Carter here? Calling case number 23346-404, Stephen Carter versus William Thompson. If you're here, please state your name. That's why the name hasn't been called, because, can you state your name, please? Mr. Thompson, can you please state your name?
Yeah, I can hear you.
Can you state your name?
William Thompson.
All right, is Stephen Carter here? Plaintiff failed to appear. Mr. Thompson, what would you like me to do?
Dismiss the case.
Our dismissal without prejudice is granted. Plaintiff failed to appear.
Okay. I do want to say that I've actually already signed another lease and moved to another location. I just have to finish getting the rest of my things out of the house, and then I can give them the keys.
That's fine. You don't have a case in here anymore. Please act responsibly, but you're free to go. Thank you.
Okay. Thank you, Your Honor. Will I get something in the mail or anything stating that this is dismissed, or?
You'll get a dismissal, and it should be accessible by the computer as well.
Okay. Thank you, Your Honor.
You're welcome. Is Laretha Bush here?
Yes, Your Honor. She's currently meeting with our staff in a breakout room.
All right. Is Brianne Davis White here? Or Carlton White?
Your Honor, this is Robert Visconti for plaintiff P61756. We've submitted a dismissal on that matter. I presume it just hasn't made it to the file yet.
Okay. Thank you for the heads up on that. Calling case number 23346-133. This is 532 Tidal Way LLC versus Brianne Davis White. Could I have your appearance one more time for the record?
Good afternoon, Your Honor. Robert Visconti, P61756 to the plaintiff. As it pertains to this matter, we'll move for dismissal without prejudice, and we have submitted an order to the court for entry.
All right, dismissal without prejudice is granted, and we will surely enter that in the computer if it isn't in process already.
Thank you.
You're welcome. I see some hands up. Mr. Santiago.
Good afternoon, Judge. I believe we may be ready on case number 298, Mariah Davis and Sharday Reed. I attempted to get Miss Davis's attention to go into a breakout room, but I don't believe she saw that.
All right. Are you sure we're ready? I'm sure
Hi.
Ms. Davis.
Hi, who was that tried to get my attention, Your Honor?
Mr. Santiago, you all want to go into a breakout room and then I'll call it?
Well, Judge, the first thing that needs to be brought to the attention, when I did some research, it appears that Miss Davis is the agent for the LLC that owns this property. Unless she is an attorney, I believe it's improper that this case was brought in her name. It's custom. Hang on, if I can give me a moment.
This matter was dismissed on the 13th.
Hi, Your Honor. You know what? They're actually trying to beat the system right now. The case is filed as Mariah Davis versus Sharday Reed and all occupants. Oh, my third court.
Case is filed as Custom Homes for Rent LLC / Mariah Davis. Who owns the property? Is Mariah Davis the owner of the property, or is Custom Homes for Rent LLC?
Correct. I'm the owner of the property, Mariah Davis. Yes.
That's not
And
correct,
this
Judge.
is the third, sorry, Your Honor, this is the third hearing. Her attorney, she jumped in here today with an attorney, Your Honor. I'm supposed to have a judgment that was
Ms.
promised to me.
Ms. Davis, this deed says Custom Homes for Rent, LLC.
Okay, so it's in my business name. I'm the sole
All
owner
right,
of
but
that
it's in
business.
your business name, and as a business and an LLC, you can't represent yourself. If it's not a DBA, if it's an LLC, you must have an attorney. That's the court rule. So you can't come in here represent your business. Even though you own it, that's a separate entity. Businesses are treated, corporations are treated as people. People who are coming in have to have representation. You can represent yourself, but your business isn't yourself. It's your business. It's a separate entity. And that separate entity requires someone with the P number to come in and argue on your behalf. So in this previous case, there's already a dismissal filed in this matter. It just wasn't, I guess it wasn't entered into the system, but I had a dismissal for this on the 13th, already filed.
Your Honor, not to interrupt you, but I am asking for some consideration here. It was dismissed because, okay, I had 2 court dates prior. Sade Reed did not attend the first court date. I attended the second court date. I had to have a surgery done on my kidney. Now they told me, because I asked when I initially filed it, they told me that it was fine, that it was filed the way it was filed as Custom Homes for Rent / Mariah Davis. I understand what you're saying, sir, but given the fact I am the sole owner LLC, and I also have another deed showing it is deeded to me as well. So this is the third court date, Your Honor. I filed the motion.
Ms. Davis, this case is dismissed. The deed that was presented with this says Custom Homes for Rent. This is the deed that you signed to reinstate it. I reinstated this case, so you can at least have an opportunity come in front. And I have no issue, I'm sorry, Ms. Davis, yeah. I have no issue with you refiling it, or I can adjourn this. I can set aside the dismissal, adjourn it for you to get counsel. If you want to maintain.
Okay, can you please at least do that for me? Because actually, I filed a motion to get the court date today. She's a squatter and she's vandalizing the property, sir. This is her first time appearing today.
Ms. Davis, I have a
This is not my first time appearing. You weren't here last time. That's
Please be quiet. Thank you.
Please be quiet.
Sir, I have several records.
So look, you gotta get your case. Your case is dismissed right now, Ms. Davis. We're gonna adjourn this for you to go find an attorney. If you wanna argue, I'm gonna dismiss your case because you can't argue. You gotta have a P number, you gotta go to law school, you gotta take the bar exam and pass it, and then come in here with that responsibility on you, then argue. You don't have that same responsibility. So I can't let you argue on behalf of businesses because you're a person and not an attorney. Okay? That's the difference.
Okay, well, instead of the dismissal, can you at least grant me an adjournment, sir? Because this is the third court date on this. Can you at least?
Since we set this up so I can set this aside. I'll grant you a set aside, and we're gonna adjourn this case. Go ahead, Mr.
Please.
Thanks, Judge. At this point, I would object. I was not aware that this
You're
matter
gonna
was
object. You're
dismissed.
gonna object, but it's a waste of time if I don't grant it. It's just gonna get refiled. So if she finds an attorney, then fine. If she doesn't find an attorney, then you can motion for a dismissal again.
Can I inquire, Judge, because I was not part of the any of the hearings previously. Was it dismissed, and if Ms. Davis was present and she knew that she needed an attorney, has she been made aware of that previously?
No, they never told me I needed an attorney, Your Honor. Thank you for setting it aside. I will have legal counsel with me on the next
I'm trying to create a record, and Ms. Davis is interrupting me.
Please be quiet. Both of you all just be quiet, please. 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 We're on the internet. You're not in person. This was set aside because plaintiff failed to appear in court. Furthermore, LLCs must have legal counsel. Okay? If I dismiss it, it's just gonna get refiled. She's here. Defendant failed to appear on the first hearing. Their service of process, there's no need to go through this again. Go get an attorney. You'll have a delay. The benefit, your defendant will be benefited and a delay. But there's no need to dismiss this case and come right back.
Thank you, sir. I really appreciate it.
And if you come back without an attorney, you're not going to, it's going to get dismissed again. But actually, no, this case, I'm going to dismiss this case and you have to refile it. I'm going to deny your motion in order because you can't file a motion on behalf of an LLC. You can't do legal work. You're doing legal work on behalf of the LLC by filing this motion. So actually, this motion shouldn't have been granted because you are an LLC. So actually, this case is dismissed. This matter will be dismissed. You have every right to refile it, but you have to refile it with an attorney. And I should have denied the motion initially because there was no attorney that filed it. So,
Sir, this has cost me a lot of time here, and I'm dealing with medical issues. I'm dealing with medical issues here. If that was the case, why didn't they tell me that when I filed it? Why didn't they allow it?
You didn't show up to the last hearing. You failed to appear.
Sir, I did contact your court clerk. I had a surgery to do on my
I
kidney.
understand it's a surgery. It could be anything. I'm sympathetic to your surgery.
But she didn't show up on the initial court date, sir.
The case is closed. It's dismissed. Please refile it with an attorney. Please refile it with an attorney because it's an LLC. You can't represent yourself unless it's a DBA. You choose to do business as an LLC. There's a cost of doing business as an LLC, and you have to have an attorney to do your legal work. You have to, or you'll be violating law. You're welcome. You feel free to refile. Calling case number, all right. We go Bornkamp and then we go Coleman. Calling case number 233462220 U.S. Bank Trust Nation versus Hubert Barnyard and Dorothy Barnard.
Good afternoon, Your Honor. Joel Bornkamp here on behalf of the plaintiff, U.S. Bank Trust National Association, P number 85016. I raised my hand because, one, I'm taking the place of an attorney that's no longer in my law firm, Ethan Hill. And then second, I would just be asking the court for a continuance date and time because it appears as though we didn't have good service on Dorothy. We have filed a summons. We spoke with your clerk. They asked that we provide the updated hearing time and date when we receive it from you at today's hearing. So I just asked the court to provide a date for us to come back and provide to you good service.
Let's come back June 5th. That should be enough time. Is that too much time? I want to make sure
no,
we can get this out.
I actually think that that's sufficient, Your Honor. Is that June 5th at 1:30 then?
Let's do June 5th at 9:30.
June 5th at 9:30. Okay.
And if there's any issue, just notify the court.
Okay, thank you, Your Honor.
You're welcome. Attorney Coleman.
Yeah, I just had one matter at 1:30. It doesn't seem like defendant, well, defendant did appear. However, they're unable to represent him, so I wanted to ask this matter be called so we can place it on the record. He's not eligible for UCHC, so I believe we can go forward on his matter. Ending in 6147.
On case number 2334647, Vince Ross Investments versus Brian Adams.
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548, on behalf of the plaintiff, this matter before this honorable court as a termination of tenancy subsequent hearing. The address is 20235 San Juan.
Brian Adams here. Mr. Adams, can you state your name for the record? Can you hit *6 to unmute?
Yes, Brian Adams is here.
All right, Mr. Adams. This is a complaint. You do have proof of service. Thank you for showing up. This is a summons and complaint to recover possession of property. When can you vacate? Are you prepared to move out, Mr. Adams?
At the moment, I'm not, but Your Honor, I would like to petition the court for dismissal of this case because I was improperly served. I never received a notice of a failure to quit. The first document I received was April 15th, and my first court date was April 27th. And also, there's I think some investigation going on with the property owner. He had received payment from like the CR program, to whereas repairs were supposed to be completed on that property, and property was never repaired. But I'm getting evicted by a company that's not even. I'm not sure if the owner is doing another quick claim scam to get into the tax program. But I petitioned the court for a dismissal of this case because I was improperly served.
Your Honor, this is Attorney Coleman. There's a proof of service in the file. The court, 36th District Court Officer, probably Court Officer Squirewell served him. There's also a termination of tenancy notice in the file. There's also a deed that shows my client owns it. Your Honor, we're asking for a judgment with 10 days to vacate.
Yes, Your Honor.
This is a termination of tenancy case, Mr. Adams. There is a deed in the file. There is proof of service. I also have a notice to quit dated February 28th, 2023 that was sent by first class mail.
I've never received a notice in February, Your Honor. I never received a notice.
You know to come here today, Mr. Adams.
I would, Your Honor. I mean, I am planning on leaving the property. I'm sorry.
Let's answer the first question. How did you know to come here today?
I received paperwork for I think it was April 15th. My original court date was April 27th, and it was adjourned to May till today.
Okay. All right. So there isn't an issue with notice. You appeared, and there's a copy of notice in the file. I wouldn't be able to verify whether something was sent by first class mail anyway, and I have proof that it was sent. So unless you have something that presents that can disprove it, and you're here, so it's kind of hard to. It's a hard argument when you have the proof of service and you also appear. You appeared at both hearings, though. Thank you.
Absolutely.
All right. So what the court is going to do, 10 days. What is 10 days? 10 days is May 22nd. We're going to do a judgment. The parties must vacate by May 31st.
That judgment by hearing, Judge?
Well, Your Honor.
Yes.
Your Honor. May I would not like to have that this eviction on my name. Is it possible that I am packing up everything, you know what I'm saying, making things situated to leave the property. I don't want my I just didn't want my name eviction on my name. Is there a way that I can be leave by May 31st without that eviction being on my name?
Attorney Coleman, is there any objection to an all occupants judgment?
Well, Your Honor, if you'd have started with that, it would have been a little different. But I'm not going to be petty. I'm a acquiesce to the court. We can do that as a judgment as to all occupants.
I'm
You just
just
asked,
asking.
you didn't ask me to do it. You just asked if I would. I understand. You didn't tell me to do it. But Your Honor, I will go ahead and do a dismissal as to Brian Adams. I did object to the additional time, but you gave it to him. That's fine. We'll dismiss as to Brian Adams and do the judgment against all occupants by hearing, if that's fine with the court.
That's fine with the court, Mr. Adams. Does that work for you?
Yes, I'm not understand. I mean, will the eviction be under my name?
No, the eviction will be under all occupants, and the judgment that is going to be entered today is a hearing judgment where all occupants must vacate by May 31st, 2023.
Oh, that's perfect for me. That's perfect.
All right, well, we like perfect. Good luck, Mr. Adams.
Thank you,
Your
Your
Honor,
Honor.
it's always
Thank
a pleasure. You yourself, the gallery, and the rest of you have a wonderful day. We'll see you again tomorrow.
All right, take care. Both of you all.
All right, thank you.
Well, Lomax Boyd, thank you for your patience. Good morning. Take your time. Take your time. We'll recall. Are you in one of those AAA cars, Mr. Boyd?
Unmute. Can you hear me now?
Yes. Are you driving?
Yeah, can you hear me?
Yeah. I'm going to let me put your hand up in the chat when you can take a break from driving, and I'll call your case.
Oh, I'm on break. I'm on break now. I parked. Come on.
All right, calling case number 2334-6185, Lomax Boyd versus Carolyn Knight.
This is Lomax Boyd.
Thank you, Mr. Boyd. It's Carolyn Knight here. Carolyn Knight. Does anyone reside at 15093 Evergreen? And Mr. Boyd, do you own the property at 15093 Evergreen?
Yes, I do.
And is the title on that property Lomax Boyd? Is that the record owner?
Yes, Lomax Boyd Jr. That's
All
my,
right.
they don't put the junior on a lot of my stuff.
Okay, you can say junior. I'll acknowledge you junior, Mr. Boyd. But okay, is Carolyn Knight here? Okay, this is a complaint for recovery or possession of property. Are you requesting a default counsel? Mr. Boyd?
I'm just requesting that she's actually in a nursing home right now that I know of, and been in the nursing home for about 2 months. And I just wanted, they left stuff in the house, so I can't put the stuff out, so.
All right, well, default judgment, are you requesting a default judgment?
Yes, if that's what it takes to get her out.
Okay, default judgment is granted. Defendants must vacate by May 22nd, 2023, or a writ may issue. So after May 22nd, first you have to submit a judgment to the court, submit a default judgment to the court. And then secondly, you want to, you're eligible to apply for a writ May 23rd.
Okay.
And I can't give you any legal advice, but that's the procedure. And
okay.
Waiting for your judgment.
Okay, thank you.
You're welcome. Have a great day.
All right, bye.
Judge, if we could mute for 1 second.
Sure.
Judge, excuse me, I'm trying to get the attention of Ms. Schuhart to go into breakout room. Ms. Schuhart, would you please join breakout room number 2? I did send you an invite.
Is Angel Pentecost Edwards here? All right, Mr. Visconti, let's see. I have some more defaults we can call. Mr. Boyd, you're free to go. And A. Smith, you're in one. Alicia Smith, are you represented by an attorney?
No, sir, I don't have an attorney.
All right, Mr. Visconti is here from the landlord's, he's the landlord's attorney. So I can put you all in a breakout room. You all can have a conversation, and if you come up with a resolution, I can call your case.
Sure, Your Honor.
She was in line to speak with our staff, Your Honor, if she's interested.
Oh.
We just haven't gotten to her yet.
Well, at some point, we gotta get to him. It's 3 o'clock, and I can't keep this courtroom open all evening. We only have 10 cases in the afternoon, and I had about 3 full-blown hearings. Parties still aren't ready, but I will hold off on that.
Ms. Smith, are you interested in speaking with someone from legal aid?
Yes, ma'am.
Okay, we'll have one of our staff bring you in a breakout room.
Thank you.
All right, thank you, Ms. Carey.
Thank you, Your Honor.
You're welcome. Is Chicago Wise here? Calling case number 2. Let's see. All right, calling case number 2334-6176, Lennox Property Management versus Chicago Wise.
Robert Visconti, P61756 for the plaintiff.
Does anyone reside at 2482 Glendale, Unit 2? All right. Thank you for your appearance, counsel. Defendant has failed to appear. Have any motions for the court?
I would, Your Honor. This is a matter for termination of tenancy, and based upon defendant's failure to appear, I would move the court for entry of a default judgment terminating tenancy with an order of eviction to issue after May 22nd.
May 22nd, 2023. Default judgment is granted. Defendant failed to appear. All parties, Chicago Wise and all applicants must vacate by May 22nd, or writ may issue thereafter.
I'll submit an order. Thank you.
You're welcome. That's 6176. It's, let's see, Asia Schuhart is in room 2 with, so 6224 is with Mr. Santiago. 6181 is in the breakout room. Laretha Bush, she's in the breakout room as well. Schuhart is in here, maybe. Armani Howard, is Armani Horton or Princess Howard here?
Your Honor, we're moving for dismissal of that matter.
Calling case number 2334-6229, 532 Tidal Way LLC versus Armani Horton and Princess Howard.
Robert Visconti, P61756 for the plaintiff. Your Honor, we'll move for dismissal of that matter. We have submitted an order. I believe it just hasn't made its way to the file yet.
Not a problem. Dismissal without prejudice is granted on case number ending in 6229. Okay, well, the court is sit tight and we'll wait until something's ready. Ms. Luan, do you have a matter ready?
I believe I've negotiated a settlement on 6172.
Okay.
Got it.
Calling case number 23346172. This is Angel Pentecost Edwards versus Corey Mundy and all occupants.
Thank you, Your Honor. Suzanne Stepich Lawan, P48702, Michigan Legal Services, on behalf of the defendant Corey Mundy, who is in the court gallery with us. Mr. Mundy, will you state your name for the record? You have to unmute.
*6. Mr. Mundy,
Yes,
can you state your name?
Corey Mundy, tenant.
Thank you, Mr. Mundy.
And the plaintiffs are also present in the courtroom, Your Honor.
All right, can you state your name, Ms. Angela Pentecost Edwards?
Angela Pentecost Edwards.
And Andre Edwards.
All right. And are you all the owners of 12112 Ward, floor 1?
Yes.
Yes.
All right, counsel. You may
Your
lead
Honor,
the way.
the parties have agreed to, this is a termination of tenancy case. They have agreed to a consent judgment against all occupants with a move-out date of June 9th. 4B will be checked, but they have agreed that they will send me a courtesy email if they intend to file for a writ. I will prepare the consent judgment. I have the plaintiff's email and will get their permission before I sign it for them and send it to the court.
Okay, and do you have permission from your client,
Mr. Mundy?
Mr. Mundy, I'm sorry, Mr. Mundy.
Yes. Yes,
Okay.
Mr. Mundy, do I have permission to sign your name on this agreement?
Yes, you do.
All right, Mr. Mundy, 4B means that if you follow the terms of this agreement, this case will be dismissed. If you don't, a judgment and a writ of eviction can be filed at the same time without coming back to court. You understand that?
Your Honor, we
understand.
actually had put it in as a consent judgment against all occupants.
Okay, let's do it as a hearing judgment against all occupants,
Okay,
but I'm okay with that. All right, okay.
thank you, Your
All right.
Honor.
Good luck, Mr. Mundy. You're welcome.
You're free to go.
Thank you. Thank you.
You're welcome.
Thanks.
Nobody from the attorney game's office here to prosecute. I think. But court denied it. Thank you, Your Honor. And once again, I hate to do it, but can I get both hours I lost at some point?
Okay. Okay, no problem. Working right now.
Thank you.
Okay. Calling case for 2238-0590. Block is in the city of Detroit. Matter is scheduled for a weekend. They have a tenant with the plaintiff.
Judge, we reached the resolution on another case whenever you're ready.
But you, fantastic. On what case?
This is 224.
Okay. Calling case number 2334-6224, 532 Tidal Way LLC versus Asia Schuherk.
Good afternoon, Your Honor. Robert Visconti, P61756 for the plaintiff.
And good afternoon, Your Honor. Robert Santiago, Michigan Legal Services, P57157, on behalf of the tenant, Asia Schuherk, who is present. Ms. Schuherk, could you please state your name for the record?
Yes, Asia Schuherk.
Good afternoon, Ms. Schuherk. All right, parties. Did we come up with some type of resolution here?
We have, Your Honor. We've agreed to entry of a consent order for conditional dismissal with paragraph 4B checked. It is a non-payment of rent matter. The rent to retain in paragraph 2 is $7,564.35. The court costs are $163.66 for a total of $7,728.01. Defendant shall pay that amount or move on or before June 12th, 2023, pursuant to the agreement of the parties.
And that is correct, Judge.
All right, so Ms. Schuherk, this is a conditional dismissal with 4B check. This is a non-payment of rent. If you pay $7,728.01 or vacate by June 12, 2023, your matter will be dismissed. In the event that you fail to do one of those two, a writ of eviction and a judgment. Actually, a judgment and a writ of eviction will be signed and filed at the same time, and we won't have to go back to court. So I just wanted to make you aware of that. If Mr. Santiago had probably already informed you of that, but just making the court feel a little bit more comfortable. And do you have any questions?
No, sir.
All right, did I miss anything, counselors?
I don't believe so, Your Honor.
No, Judge.
All right, can Mr. Santiago sign your name on this consent, on this conditional dismissal?
Yes, Judge.
Okay, all right, well, you all have a great day. Mr.
You too.
Santiago, it's 82 degrees outside.
Thank you, Your Honor.
Yes, I have church choir practice tonight, Judge. So, thanks, Rob. Thanks, Judge.
Thanks, Robert. Have a good day.
So we just have Alicia Smith and Larissa. All right. Ms. Bush,
Yes.
Are
We've
you
reached-
ready?
We've reached a
Yeah.
resolution on her case, Your Honor.
Okay, calling case number 2334-6129. This is Core International Group versus Laretha Bush.
Good afternoon, Your Honor. Robert Visconti, P61756 for the plaintiff.
Suzanne Stepich Lawand, P48702, Michigan Legal Services, on behalf of the defendant, Laretha Bush, who is here in the courtroom with us. Ms. Bush, will you state your name for the record, please?
Laretha Bush.
Thank you, Ms. Bush. All right. Who would like to put the terms on the record?
I'd be happy to, Your Honor. The parties have agreed to enter a consent judgment as it pertains to all occupants only, terminating tenancy with a writ date of June 9th, 2023.
Well, it was my understanding that the move out date, is that the same as the writ date? Would be
Yeah,
June-
so the move out date would be June 9th. No writ would be available until the following Monday, which is the 12th.
Okay. Just wanted to make sure we were clear.
100%.
Okay, so parties must vacate by June 9th. And based on the calendar, a writ couldn't be applied for until June 12th. But let's do it as a hearing judgment, a judgment by hearing. I know parties agree, but with all occupants, it just works out a little better as a hearing judgment. With the vacate date of June 9th.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Thank you.
welcome.
Everyone
All right.
have a blessed day.
You as
too.
well.
All right.
Bye-bye.
Bye.
Bye. This is Alicia Smith. That's one. Yeah.
This is for that, 411,
Let's see. Calling case number 2334-6411. This is Kathleen Malone versus Tyree Rump and Tressa Copeland. Probably Teresa. Copeland. Attorney for Waz's case. Parties failed to appear. Looks like a dismissal was previously entered
yeah, I think that's it.
on April 24th. So parties failed to appear because a dismissal was already entered. So the court will enter a dismissal without prejudice on the record, which would conclude this matter.
You have a good weekend, Your Honor. I'll see you next week.
I think we still have one more. don't we?
Yes, there's an attorney covering it. She's in a breakout room.
Okay, all right. Have a great week. Have a great weekend.
Excuse me, Your Honor, could I ask your clerk or the court reporter a question about a case from earlier?
Sure.
I was just wondering, I was taking some notes for, well, all of our attorneys, but for Ms. Fisher, and there was a case ending in 6220 with an attorney Born Camp, and I was just wondering what the adjournment date was on it.
I got it, Judge, June 5th at 9:30.
Thank you very much, Ms. Davis.
All right, and that's with Herbert and Dorothy, right?
Yes.
All right, yeah.
Thank you.
Adjourned to June 5th at 9:30.
All right, thank you.
Get me to June tonight.
Judge Sabree's courtroom, how may I help you? Okay. Did they give you a court date?
Last but not least, calling case 2-3-3-4-6-1-8-1. This is Eagle Home Maintenance LLC versus Alicia Smith and occupants on Curtis.
Good afternoon, Your Honor. Robert Visconti, P61756 for the plaintiff.
Good afternoon, Your Honor. Janetta Fisher, P72872 with Michigan Legal Services representing Alicia Smith. Ms. Smith, please state your name for the record.
Alicia Smith.
Thank you, Ms. Smith. All right, were parties able to work out a resolution on this matter?
Yes, Your Honor, we were. The parties have agreed to entry of a judgment against all occupants. We understand that will be by hearing, terminating tenancy with a move-out date of June 9th, 2023.
And Your Honor, what I would like to add is to not have Ms. Smith's name on the judgment.
Okay, so I'll do a judgment by hearing as to all occupants. This is the termination of tenancy hearing with the move out date of June 9th, 2023. So all occupants must vacate by June 9th, 2023, or a writ of eviction can be applied for that following Monday, June 12th.
Thank you, Your Honor.
You are welcome. Well, have a great day.
Ms.
You
Fisher, if
too.
you
Thank
return
you,
that
Your Honor.
signed to me, I'll go ahead and forward it to the court for entry, okay?
Okay, I will do that now. What were you saying, Ms. Smith?
I was saying thank you.
Oh, okay. You're welcome.
Have a good day, Your Honor.
Okay. All right. Bye-bye.
All right, take care. Don't be late, Mr. Santiago.
I can leave now.
Yeah,
Yes,
you can
Ms.
leave.
Smith.
Thank you, Your Honor. Have a blessed day.
All right, you too.
Thank you.
Okay,
Thanks,
everyone have
Judge.
a good evening.
Thank
Thank
you.
you,
You
Ms.
too, Ms.
Davis.
Davis.
Everyone enjoy that 83 degrees now that the judge mentioned.
Oh, okay.
Oh, my. Bye-bye.
I'll try.
Thanks, Ms. Carey.
Thank you. Have a good weekend.